Currently, we are going through the SRA's set sample. Of course, they're not nice enough to give us the actual past exam papers, but we're not going to hold it against them. This is the most authoritative source that we have to go through. I'm going through the questions from the FLK set that the SRA has made available, and I take them as an opportunity to give you guys a little revision of what the substantive topic of the question is, and then explain why the correct answer is correct, and also explain why the wrong answer is wrong. So that way you guys have the opportunity to go through the sample with me, which you need to do. Everybody needs to go through this sample one way or the other. So we do it together, so you're not on your own. I explain the correct and the wrong answers, and I give you a little bit of a revision or a background or some tips on the substantive topic as well. Question 60. 3 solicitors set up in partnership 6 months ago. They shared profits equally and ran their business from an office owned personally by one of the partners, which he bought 7 months ago. The partner who owned the office has unfortunately now died. At the date of his death, the partnership business was valued at £900,000 and the office was valued at £700,000. Which of the following best describes the availability of business relief for inheritance tax in respect of the deceased partner's interest in the partnership business and in the office? Anybody knows anything? These are the worst. I mean, other than land, nobody likes land law, okay? But at least when people are at uni, they don't like land law. But for the purposes of the SQE, nobody seems to know anything about inheritance and taxation. Now, this question beautifully combines these two horrible topics in one horrible set. So you got a question that is about inheritance and taxation. So yeah, I mean, they really tried their best to kind of disadvantage us with this one, yeah? So, I mean, what do you want me to say? This is not a question that I would have been able to answer, and I've already done videos on succession, okay, and on the tax implications, and still I wouldn't be able to answer this question without looking this information up. So, if you're reading this and you're thinking, what is this? Then I'm totally with you. Now, what do you need to know about this? Unfortunately, you need to have some knowledge of the Business Relief Inheritance Tax Act of 1984, which explains the circumstances in which one might claim business relief from certain types of inheritance-related taxation. Requirements are of a trading nature and of an ownership nature. So the trading aspect is that we are looking at a qualifying business. Not everything is a qualifying business. And we need to have the asset in relevant ownership 2 years. That's a sticking point here. 2 years before the death of the owner. Okay. Let's look at the possible questions. So the question again is, can they claim business relief for inheritance tax? Option A is the interest in the partnership business and the office will both qualify for business relief at a rate of 100%. B says the interest in the partnership business will qualify for business relief at the rate of 100%, and the office will qualify at 50%. C says the interest in the partnership will qualify for business rates at 100%, and the office will not qualify. D says the interest in the partnership will not qualify, and the office will qualify at 50%. Okay. And E says neither the interest in the partnership nor the office will qualify for business relief. All right. What do you think is the correct answer here? It's a horrible answer. And you know what? This is weird because it's not very often that you have 4 answers that are pointing in one direction that some relief is possible, only 1 answer saying that no relief is possible, and the completely negative option being the correct answer. So the correct answer here is E. Neither the interest in the partnership business nor in the office will qualify for business relief. Okay, so I wouldn't have, if I was guessing, I wouldn't have guessed this, because if I'm getting 4 options that are pointing in to say yes with various caveats and only 1 pointing out no, you gotta be thinking, if they put like kind of 4 possible answers in one direction, then the correct answer is probably a yes, right? But unfortunately, in this case, you would be wrong. Now, why is that? The problem here, guys, is the 2-year limit. So I agree that a privately owned asset that is also having business use would qualify for some level of relief. Usually you would get the 50%. But that's not where the problem is coming from here. The problem is coming from this immovable barrier of the 2-year precondition. So none of the interests here, neither the interest in the partnership nor the interest in the office, in the real estate, is more than a few months old. So unfortunately, the correct answer is E. Nobody qualifies for business relief. Anybody here wants to be a tax lawyer? You could help us out, all of us. Yes. I mean, I'm not saying this is not a good idea. It's a great idea, because money is to be made by things that are difficult and things that people don't want to do. So nobody enjoys doing tax stuff. Trust me, I spent the morning yesterday talking to HMRC on the phone. Nobody wants to do that stuff. Alrighty. So, are we ready for our next question? How are we doing so far? Are you guys enjoying the show? Should I accessorize in more Christmas-related outfits as we're getting closer to the holiday? Let me know in the chat or in the comments under the video if you're watching this on replay, or give me like a click the thumbs up or something if me dressing in a Christmassy manner is improving your absorption of this incredibly dry SRA created material. Yeah, let me know and I'll do it. We aim to please. Okay, so we are gonna move on to question 61 now. Let's just grab the correct thing. Aha! You know what? This is a horrible set. Like every week, I pick like 5 or 6 questions. I'm going with the way that they're published on the SRA website, right? So I'm taking them in sequence so you guys can kind of play along with me. It's incredible how the set varies in difficulty. Some weeks we have a set that's very straightforward. Sometimes we have a set that's horrible. This set is horrible, okay? So we started off with a civil procedure question that probably nobody knows the answer. Okay, maybe the tort was more achievable. The Equalities Act, difficult. The tax, horrible. At least now, the penultimate question, we're having one that is achievable, because this one is contract law and you guys ought to know it. Let's see. Okay, a customer buys a television from a shopkeeper on the 24th of December. Don't do that. Don't do your Christmas shopping on your last day. Do your Christmas shopping now that the Black Friday sales are still on. So it is a gift for his daughter. He does not inform the shopkeeper that it is a gift for somebody else. When his daughter opens the box, she discovers the television is defective. She travels to the shop on the 26th, on Boxing Day, that's ambitious, and asks for a replacement or a refund. The shopkeeper refuses. What advice should be given to the daughter? Is it A, the daughter has rights under the contract because she suffered the detriment in traveling to the shop? B, The daughter has rights under the contract because of an objective, because on an objective test, the television was likely to have been purchased as a gift for a third party. C, the daughter has a right under the contract to have a television replaced only. D, the daughter has no rights under the contract because she was not a party to the contract. E, the daughter has no rights under the contract because it is a domestic agreement between members of a family. Oh, hey. Now, come on. This is easy. We've got people watching live. Venture a guess as to which one might be the correct answer. The field, the topic is the doctrine of privity. This would fall under FLK contract law, which is my favorite topic, and some of my best performing videos are my contract law videos. And I'm pleased because I've been teaching contract law for more than 20 years. I started teaching at the University of Kent in, yeah. Did you guess that I'm this old? Yeah, that's like the correct answer. I mean, I told you doctrine of privity, so surely, yeah. The correct answer is answer D. The daughter has got no rights under the contract because she was not a party to the contract. I know that I know what you guys are gonna think. You're gonna be thinking, ooh, it's purchase, it's defective goods. This has to do something with consumer rights. Everything act and rights to a replacement, repair, rejection, all of that stuff. And if you were thinking along those lines, you would have missed the fact that the key legal issue question is the identity of the person complaining. Yeah. So the doctrine of privity says that people who are parties to the contract have rights and obligations under the contract. Who are the people who are part of the contract? How can we work this out? We can work this out by figuring out who provided consideration. If you have not provided consideration, then you're not a party to the contract. There are circumstances in which a named third party might become a beneficiary, and in that case, acquire rights to sue to enforce obligations under the contract. That's why we've got the Third Parties Act of 1999. The Third Parties Act specified that if you don't want this to happen, if you're mentioning a third party as a beneficiary, but you don't have them, you don't want to give them the rights to sue, then you can expressly exclude this into the contract. So all that's great, but it's all also irrelevant with what's happening here, because here the customer never said that he was buying on behalf of somebody else. So the customer provided consideration, the shop provides consideration by giving the TV, the daughter has provided nothing, she's not a named beneficiary, this all stayed in the purchaser's head, therefore she has no rights under the contract. Now, whether she suffered the detriment in traveling to the shop is irrelevant, okay? An objective test for is this being a gift, it's irrelevant. This isn't how the law works, okay? I mean, for that matter, you could assume that anything you buy from these kind of Black Friday sales all the way up till the January sales is a gift for somebody else, okay? That's not how it works. Whether the right is to have the television replaced as opposed to repaired or any of that stuff, again, is irrelevant, yeah? This isn't what the question is about. And E said she's got no rights because this is domestic agreement. No, what she's trying to enforce is not to enforce against her father. She's trying to enforce against the shop. Again, it is a privity problem. So correct answer here is D. She's got no rights under the contract because she's not a party. Now, if you guys are loving multiple choice questions for the SQE, and who doesn't, honestly, if you're preparing for SQE1, especially if you're preparing for the January sitting and now you're in kind of full tilt in your preparation, you're probably dying to have more MCQs. And I've got a solution for you guys. I've got a newsletter that I'm sending out every Monday. The newsletter contains a fresh, not SRA sample, mine, okay? Freshly created, right out of the oven MCQ. So what you're gonna get is this MCQ some reading material or a related video to watch on the substantive topic, and then you're getting a full explanation of the previous week's MCQ, as we're discussing now, but kind of written down. And you're also getting a set of goodies like discount codes for relevant products and services, suggestions for additional reading, other things that I have come across that I think that you guys should know. So all of this is on my free newsletter that is coming out every Monday and it's going to the community. How are you going to participate, you ask? You email newsletter@glintis.co.uk. So you email this and I will put you on my mailing list and you're going to receive this every Monday in your inbox. I don't guarantee a time. I send this manually, so it comes at random points during the day, but you're going to get that newsletter. And then, you know, there are links attached to this. If you guys are looking for a study planner as well, subscribers to the newsletter, they get the link to my study planner. This used to be a nice PDF printout. Now I've also created a digital version. So it's an app that you can put your starting date for your preparation, your target examination date, and it's going to spread out the FLK across all the weeks that you've got available and tell you what you should be studying every week in order to prepare adequately to have covered the entirety of the FLK by the time you get to your intended examination point. And it doesn't simply spread things like that. It's got a weighting inside as to which ones are the heavy topics, which ones are easier, and allocates the time accordingly to make this more meaningful. So all of this comes to the people who are subscribed in the newsletter. Maybe a lot of you guys are already there, but if you weren't, now you know how to join. So are we ready for our final question? Our final question is going to be question 62. Okay. Let's try and navigate to this. Now, this one, guys, seriously, this one is tricky. And the main reason it's tricky is because it is so lengthy. So remember what I said earlier, right? You have 2 minutes, less than 2 minutes per question. Yeah. So imagine having to go through all of this to be able to navigate this effectively. Yeah. Okay. Now, let's get going. During a visit to her uncle, a woman is badly bitten by his dog. That's why we've got cats. Not much chance that Nuggets is going to eat you. He's going to eat your bread or your cookies or anything you leave outside or your crisps, but he's not going to eat you. Her finger is severed in the incident and requires surgery to reattach the finger. She's advised by her doctor that it will not be possible to figure out whether the surgery has been successful for 6 months and a further operation may be needed. She will also require physiotherapy. The woman gives careful thought to claiming compensation from her uncle. She concludes that she will pursue a claim. The uncle wishes to avoid the cost and delay of court proceedings and would prefer the claim is resolved through ADR. The uncle puts forward a close friend who's suitably qualified to conduct a mediation. The uncle says that his friend has excellent qualifications and that they will not find anybody better. The woman is uncomfortable about the proposed appointment. She is worried that she will not secure full compensation if she does not issue formal court proceedings. The woman decides that mediation is not appropriate and she would like to instruct the solicitor to issue proceedings. Which of the following statements best explains why the woman should decline to participate in ADR as proposed by the uncle? So this is given to you by the question, okay? So the objective is avoiding ADR. So we're not debating whether ADR might be a good idea or not. We're debating that she does not want to do it in the terms proposed by the uncle. So possible answers. A, the mediator will not be truly independent because he's a friend of the uncle and has been selected by him. B, the woman will have to be unrepresented in mediation and will not therefore have the benefit of legal expertise in presenting a case. C says that the mediator has the authority to impose a settlement on the woman and she's concerned she will not receive full compensation. D says the woman will be required to meet her own cost of mediation, whereas she can recover all her costs if she is successful in court proceedings. E says the cost of mediation are likely to be disproportionately high compared to the cost of resolving a claim through the court. Okay. So if you had to pick an answer, which one do you think would be the best answer here? So remember, we're not debating the merits or dismerits of mediation. We just trying to explain why she should decline to participate in ADR as proposed by the uncle. The correct answer here is going to be A. She should not accept this offer of mediation because the mediator is not independent. If it is somebody that's been selected and by the uncle and is a friend of the uncle, then he's, well, I shouldn't say he's unlikely to be objective, but I would say we're running a serious risk of him not being objective. Yeah? So A is the correct one. This is the primary reason why she should decline this offer. She can, of course, she would be advised to move on with mediation, right? In any event, the court, if she wants to go to litigation, the court most likely will send her to mediation first. And as the rules have changed now, she will be obligated to go through that step. Remember that this is civil procedure. Alternative dispute resolution is getting increasingly incorporated in the CPR. Recent changes actually bring this in a lot closer. So now having to consider ADR as part of the litigation pathway is what is going to happen. So the vast majority of disputes of this nature will have to start with mediation, whether the parties think it's a good idea or not. This is going to be mandated by the court. If you don't participate in the mediation, then you run the risks of having cost penalties if you move on to trial and you lose. But this isn't what we're talking about here. What we're talking about here is this particular mediation, the way it's been set up by the uncle. So the correct answer is A. Let's look at the wrong ones. The woman will have to be unrepresented in mediation and will not therefore have the benefit of legal expertise. This is not a significant reason. People are not normally bringing solicitors to mediation. The idea of the mediation is to work on, to establish the factual basis, and the mediator to work with the parties in finding an acceptable solution. It is not to argue the legal merits or dismerits of their position. C says the mediator has the authority to impose a settlement. No, this is wrong. The mediator does not have authority to impose a settlement. The mediator helps the parties reach agreement, and if the parties reach agreement, then it's fine, it's represented in a contract. D, the woman will be required to meet her own costs of mediation, whereas she can recover all the costs if she is successful in court proceedings. Not necessarily, well, or no, she's definitely not going to recover her costs for sure if she's successful in court proceedings. It also depends what you're calling costs. She won't be able to retrieve the costs of her own legal representation, for instance. This is very unlikely. And she would be sharing the cost of the mediation with the uncle, most likely, and they're not very expensive, which also shows why E is wrong. E says the cost of mediation are likely to be disproportionately high. No, they're not. Mediation is an affordable pathway in resolving disputes in much superior ways than going to court. So all of the potential answers here, the 5 out of the 5 potential options that you've got, the 4 are wrong, either in law or in fact. The one that comes the closest, and it is actually like a legitimate reason why you would want to refuse mediation in these circumstances, is A. A local council introduces a ban on school-aged children entering coffee shops, shopping centers, and cinemas between 8 a.m. and 6 p.m. on school days. This decision is an attempt to reduce high levels of truancy in city center schools. It is made under legislation giving local authorities full discretionary powers to introduce measures aimed at improving educational attainment, and it is introduced without any public consultation. Local businesses are, of course, outraged by this decision, and they seek legal advice. Many of them rely on trade from local school children, and since school lessons finish at 3:30, they cannot see how the ban up until 6 p.m. can be justified. There are no human rights issues here. The question: which of the following statements best summarizes the basis on which this decision could be challenged under judicial review, or through judicial review? So the topic here is in the sort of administrative and constitutional law and public law components of what you're revising for the SQE. This would fall under FLK legal system. And this question has to do with the ability of people to challenge government decision-making, either local or national, on using the tool of judicial review. So what are our available options? A is if the decision does not give sufficient weight to the interests of the local businesses, then it can be challenged through judicial review. B says if the decision does not result in a demonstrable improvement in educational attainment by local school children. C says if the decision is one which is not the most cost-effective in the circumstances. D, if the decision does go significantly beyond what local authorities are doing elsewhere to address the same issue. E says if the decision is so outrageous, it is in defiance of logic that no sensible person could have arrived at it. Okay, so we need to think about what can power a complaint through the medium of judicial review. Is it the match between what the government is trying to do and the tool that they choose to achieve this? Is it a sort of policy discussion, whether this is the best policy solution? Is it a comparison with comparable situations in the past or in other jurisdictions or in other local authorities, as the case might be? Or is it a higher standard of, like, this decision is crazy and it makes no sense, and no sensible person would have arrived at this decision in order to achieve those outcomes? So where do we set the threshold in order to be able to complain? So the question again was, which of the following statements best summarizes the basis on which this decision could be challenged through judicial review? Now, we've got a few people watching us online. If you would like to venture a guess in the chat that is next to our video screen here, we've got the chat there. So if you would like to pick A, B, C, D, or D and put it in the chat, I can have an idea of what people think. Now, shall we go through them one by one and see which one best matches? Oh, we got a suggestion there, thank you, that says D. Okay. Let's try D. If the decision goes significantly beyond what local authorities are doing elsewhere to address the same issue. And another vote for D. Okay. Thank you for the vote. But guys, unfortunately, you're wrong. Because whether other local authorities have tried the same measure or whether the measure makes sense from a kind of policy effectiveness point of view and whether it's widely adopted is not a reason to complain through the judicial review process. Equally, A, that says if the decision does not give sufficient weight to the interests of local businesses, is not up to the court to decide. So neither do we have a sort of expert analysis independent of this, nor do we appoint the court as the expert assessor as to whether this is the best way to achieve the policy outcome. So A is wrong, D is wrong. B says if the decision does not result in a demonstrable improvement in educational attainment. No, again, it is not the job of the court to substitute the opinion of the government as to how to achieve policy objectives. C challenges whether the measure is cost effective in the circumstances. Again, the courts do not have the ability to challenge the government's risk and cost assessment analysis. So effectively, if A, B, C, and D are wrong, the only thing we're left with is E. E says if the decision is so outrageous in its defiance of logic that no sensible person could have arrived at it. I mean, this sounds a bit harsh, and I can understand why you gravitated against this one, because this sounds too extreme as a measure. However, this is the measure that one could use in judicial review to challenge the government's decision making, because since this is a matter that's up to statutory discretion that is given to the local authority, and since it raises no human rights issues, we don't have any other way to challenge. This standard of something like the government has done is crazy, is called Wensbury unreasonableness. It comes from the Wensbury case, and it is in fact a very high standard, but it is the only standard available. So the court's role is not to substitute the policy-making role of politicians. It's not to assume the role of experts in assessing policy outcomes. It's not there to determine the best pathway to achieve a policy objective or to challenge the objective itself. The standard is simply, if a government, local or national, is exercising a statutory duty, do they exercise the statutory duty within, the parameters of their statutory authority, or are they doing something that has no logic, is completely unreasonable, that no sensible person would have decided to do? Now, this is in fact a high threshold, but it has been used successfully in the past to challenge, public authority decision making. So this is the correct measure here. In order to get some deeper information on this, you can see the videos that I've got on the legal system, public law, and constitutional law that provides a little bit more context. So I think what we can all fairly easily agree on is that judicial review is the mechanism that exists in the law to challenge public decision making. But then what you actually need to do in your complaint in this judicial review process will depend on the circumstances. We have come questions in the past that had to do with human rights implications. And that's an easier way to challenge government decision making, because then you've got the entire structure of the European Convention of Human Rights and the jurisprudence that has developed around this, that makes it easier to demonstrate where the government decision is deviating from those standards. But in the absence of this, in areas of pure discretion for public authorities, then the Wensbury principle is pretty much the only thing we have to go. So thank you very much for contributing your suggestions. I see why you would have arrived for D as the correct choice, but in fact, in this case, the correct answer was E. And if you thought this was complicated, the next one is even worse. So let's scroll down to our next question. I told you already that the set that we've got today is not particularly pleasant. Yeah. Okay. Now, in this one, question 64 from the SRA's set of FLK1 questions. To fund a breach of contract claim, a claimant enters into a damages-based agreement with a firm of solicitors set at 20%. The claimant's solicitors pay a disbursement of £5,000. The action is settled. A settlement order is drawn up under which the defendant agrees to pay the claimant damages in the sum of £150,000 and agrees to pay the claimant's solicitor costs of £10,000 plus disbursements of £5,000. The defendant pays the amount due to the claimant's solicitors. The claimant's solicitors now calculate the amount they can deduct under the damages-based agreement. The solicitors will remit the balance to the claimant. What sum will the claimant receive from the solicitors? Is it A, £130,000? Is it B, 120, C, 115, D, 148, or E, 117? Now, you guys are aiming to become solicitors. Probably you hate numbers and math, because traditionally the people who gravitate towards law school are the people who just are terrible at sciences and math and all of that stuff. Now, unfortunately, the SRA wants to put its finger where it hurts, so we've got quite a lot of tax questions, inheritance questions that require calculations, and we've got all these solicitors fees questions as well. So let's see. We have a suggestion in the chat that says A, 130,000. Okay. Anybody willing to, this sounds like an auction. Anybody willing to raise their bet and opt for a higher amount, or perhaps lower their bet and opt for a lower amount? And if you're wondering what is this stuff and where could I possibly get information on this, this has to do with solicitors practice and solicitor accounts. I've got a couple of videos on these areas, and I'm developing more to offer you guys more context. But it has to do with the professional behavior and obligations of solicitors, and handling client money is a big component of FLK legal services. I've got a video coming up on that one, on explaining FLK legal services that it would be good for you guys to watch. So let's see, we've got two suggestions here. One suggestion in the chat is for A, which is 130,000 pounds. Another suggestion has taken us lower at 120. Okay. Now, let's work this out. Okay. We can ignore the 5,000 pound disbursement. Okay. Because the claimant solicitors have paid these disbursements of 5,000 pounds, but these have been reimbursed by the defendant through the settlement agreement. So the 5,000 gone away, they don't feature on this, they've been paid externally to this whole calculation. In addition, the claimant has, the defendant in the settlement has agreed to pay the solicitor costs of 10,000 pounds. Now, when we come to calculate what's happening here, if we take the DBA amount, which is the damages-based agreement, right? And the DBA amount is at 20% of the total. If we do 20% of 150,000 pounds, that results in a 30,000 pound fee. If we deduct the 30,000 fee from the 150, that is the damages paid to the claimant, then we end up with an amount of 120, which is what I'm guessing motivated one of our audience here to suggest B as the correct answer. However, what are we going to do with the 10,000 pounds that the defendant has agreed to compensate as solicitor's expenses? The problem is that since we've got these additional 10,000 pounds, were we to deduct the 30 from the amount of 150, so were we to deduct the DBA percentage from the 150, we would end up overpaying for the solicitors, because the amount of money that the solicitors received is 150,000 plus the 10,000 plus the 5,000. We already took the 5,000 away. So if we deduct their fee fully out of the 150,000, what are they doing with the rest 10,000 that they're going to receive as solicitor's cost? They're pocketing it on the top. That's why we should take these 10,000 pounds that have been prepaid by the defendant out of the DBA amount. So 20% of 150,000 would be 30,000, but we're deducting these 10,000 pounds because these are paid by the defendant. And then we're left with 20,000 pounds that needs to come out of the amount paid in settlement. So the correct answer is answer A. Did that make any sense to anybody, or have I confused you guys? Yeah? So give me like a thumbs up or something, or an emoji if this worked out, or whether you want me to explain this again. Think of all the money that the solicitors are getting here. They're getting the 150, then they're getting the 10, then they're getting the 5. So the 5 we're taking out of the calculation because they are disbursements. But we need to keep in mind that the defendant has already paid 10. The total amount that the solicitor is going to be paid on the DBA is 30,000. But we cannot deduct this 30,000 from the settlement sum of 150 because then they already pocketed the 10, which means that they would make in excess of what their agreement was allowing for. That's why we are taking, if the DBA amount is 30,000 in total, we're taking out the 10 that the defendant has already paid, and then we're taking out another 20 on the basis of the DBA from the settlement sum, and then we're left with 130. That's why A is the correct answer. Yes, so I don't like it any more than you do. This is not an easy answer, right? That's why I'm trying to make specific videos for these things that take you through this content really carefully, so then you can navigate certain complex calculations. Now, I don't know, maybe this is not a complex calculation. Maybe it sounds complex to me because I'm terrible at numbers, but I think most of our colleagues will agree that you don't become a lawyer if you're supremely confident with numbers, right? If you were that good with numbers, you probably would have become a scientist or something. Now, on FLK legal services, I've got a video that is coming up. It is already available for our channel members. What happens is that all the videos that I have prepared, they're all queued up to publish. We have a new video coming out every Saturday. Now, on occasion, I'll publish something midweek as well if I've got something extra that I want to share with you guys quickly, but our kind of standard publishing schedule is every Saturday. Now, I've got all these videos prepared and they're waiting on a queue. For those of you who are supporting the channel financially, so you're paid channel members, which only costs, because like less than the coffee, I'm telling you, for only $2.99 a month, all these videos are instantly visible, even though they're sitting in the queue. So you can watch all these videos straight away. If you're a channel member, you can watch the Legal Services FLK video straight away. If you are not, and then you can wait in its queue, and it's going to publish in one of the coming Saturdays, and then everybody can see it for free. Now, what I've been trying to do is to create videos that match exactly the SRA's specification. Now, I took the syllabus as it's published on the SRA website, and I built my videos around that, using that as a table of contents. So that way you guys get to hear only the information that you need, and it is delivered in an order that you can actually follow against the SRA's specification. So you don't waste your valuable time learning about things that are not relevant to the exam. The purpose of engaging with this material is to prepare for SQE1 specifically. So these videos now are 100% tailored to SQE1 requirements. And I've put as well, I made it into a course because that's a new thing that YouTube does. It gives us the ability to package these playlists as a course. So it's got all these videos that are kind of FLK absolutely specific all together in the same place, so you can watch them together. No. So we've got a question in the chat that says, are some topics weighted more heavily than others in the SQE, or do all topics have an equal amount? Well, they don't commit to having the same amount of questions per topic. So it could be that more questions turn up on one topic than others, but all questions are worth the same marks. Okay? So they have a lot of questions that they can throw at you between FLK1 and FLK2 at the SQE, because you got exam sets that contain 180 questions, okay? Out of all these questions, surely they've got the ability to examine every single thing in the FLK. But there is nothing to say that there's going to be like 2 questions on each topic or 3 questions on each topic. It could be that some topics contain more questions than others, depending on the examination sitting that you're taking. So yeah, all questions are worth equal marks. All topics are examinable and probably will be examined. How many questions you get per topic is a matter of luck. So hopefully this addresses your question. Are we ready to move on to our next question? which is going to be question 65. Okay, now this is an unpleasant one. So an adult man is killed in a car accident. A woman is liable in negligence for causing the accident and the man's death. The man is married at the time of his death and is survived by his wife and their 1-year-old son. The man is also survived by both his parents. The man's wife, son, and parents are all dependent on the man. How sexist. The man has made a will leaving all his estate to his wife and son. Alrighty. Who is entitled to bereavement damages for the man's death under the Fatal Accidents Act of 1976? I mean, Jesus Christ, okay? If you've never heard of this act, you would have no clue what's going on here. And to be honest with you guys, before I researched those questions, I didn't have a clue either. No, and I've been doing this stuff for 20 years. Imagine, 20 years of teaching this stuff and teaching tort, and I never came across the Fatal Accidents Act. So you will, on occasion, get questions that are targeted to specific legislative instruments. Now, if you're lucky and you know about it, you know what the correct answer is. If you're unlucky and you don't know about it, then you have no clue what the correct answer is. Anybody have got any clues here or what the correct answer might be? Maybe you guys are better in these types of topics than I am. But I had to look it up because I didn't know, right? So the correct reference here is section 1, subsection A of the Fatal Accidents Act of 1976. And drum roll, who's gonna get the money? Yes, because we're thinking about bereavement damages. Yes, so whatever else is happening with will and estates and stuff seems to be a misdirection. We're only thinking about bereavement damages that the defendant, in which case the woman who caused the accident, is going to pay. Yes, we have the correct answer in the chat. Thank you very much. The man's wife only is able to claim bereavement damages under Section 1 of the Fatal Accidents Act. Why is this? Because that section sets out who are eligible claimants. And in that case, eligible claimants are going to be the wife, the husband, or the partner if they're cohabiting. This is like a more recent introduction to the law from 2020. The wife, husband, or partner of the person killed. If the person killed is underage, then the parents of the kid that's been killed have got the ability to claim for these bereavement damages. Here we're talking about the death of an adult, so his parents are no longer relevant. And since the man had a wife that survives him, she is the one who gets the claim. The son is not one of the eligible claimants. So A is wrong. The man's a grown-up. We don't care about his parents. C is wrong because children, like descendants, are not eligible claimants. Wife and son, wrong for the same reason. Parents, wife, and son, wrong for the same reasons. So the only option that we're left with that's going to work is B, which is the man's wife only. Yeah? Okay. Hopefully we don't get to kind of come across any of these situations in real life. What do we have next? Question 66. A woman does not make any disposals for capital gains tax purposes in the 24-25 tax year. She made £2,000 losses for capital gains purposes in the previous 23-24 tax year. Question: which of the following statements best describes the woman's capital gains tax position? Can she carry forward both her £2,000 losses and her 24-25 annual exemption indefinitely until she has an opportunity to use them? Or can she carry forward her £2,000 losses indefinitely until she has an opportunity to use them and can carry forward her 24-25 annual exemption 25-26 only? Or C, can she carry forward her 2,000 losses to 25-26 only and can carry forward her 24-25 annual exemption indefinitely till she has the opportunity to use it? Is it perhaps D, that says, can she carry forward her £2,000 losses to the 25-26 year and only, and cannot carry forward her 24-25 annual exemption at all? E says she can carry forward her £2,000 losses indefinitely, yeah, until she has an opportunity to use them and cannot carry forward her 24-25 annual exemption at all. Now, this is a horrible question, not because it is on capital gains tax or tax issues in general, which might mean that people are not very familiar. It's a bad question for a different reason, because you've got a very small scenario. I'll give you that, no problem there. But you have a very lengthy, very wordy, and very repetitive possible answers. So you're going to have to read this so carefully to figure out which ones say indefinitely, which ones say next year only, and in what combination do you get it. And this is intentionally put in language that is repetitive because that makes it more confusing. This is a significant problem, both because it can genuinely confuse you when you're reading it, and also because you need to read all this under significant time constraint. Now, nothing in here is irrelevant, like in the previous question, because we got a question in the chat about this. Your colleague there says there was a detail about negligence. Is that irrelevant? In 65, well, that is the woman in the car accident was liable for negligence. In negligence, yes, that shows the reason why she's responsible for the accident. It doesn't really change anything in the calculation in figuring out who might be an entitled recipient under the Fatal Accidents Act. It doesn't. Equally, where it says about the man leaving his estate and stuff, that also seems to be irrelevant. Now, this is quite unusual because normally they don't stick irrelevant facts in those questions. It seems that this one they decided to go a different way. Normally, everything they put in the question is there for a specific reason, is not simply there for misdirection, right? Now, coming back to this question, you have less than 2 minutes per question, right? You've got so many questions to address, and you're doing it under severe time constraint. So your ability to read effectively, quickly, and understand what each possible option says and keep it separate from all the other options is really not easy at all. And when you get a question which repeats the same information with very small variations, it makes the task a lot more difficult. Now, the traditional structure of a question of an MCQ for SQE1 is that you're going to get like a fairly chunky scenario, usually longer than this, right? The scenarios are normally like 4 or 5 lines and so on. So you get like a chunky scenario, and then you get a set of 5 possible answers that also tend to be quite wordy. And they aim for consistency. So when you look at it, it looks the same. So it's not like one possible answer is yes, and the other answers are all kind of long sentences, right? They make it in a way that the possible answers all look consistent, at least on the first visual inspection. Now, the big challenge about this is that normally they don't stick irrelevant stuff in the questions. So if you get a wordy scenario, you need to pay attention to every single thing that it says, because minor details in that scenario might really affect the outcome. And then you've got the very difficult task in the very constrained time frame of actually going through all the 5 possible options and kind of getting the little nuances and differences between them. Now, only one is going to be the correct answer. It's like Lord of the Rings. You guys are fans of Lord of the Rings? where they're all obsessing about the ring, and then there can be only one person that has the ring. That's the extent of my knowledge, by the way. Yes, I mean I haven't gone past the trailer, but everybody's obsessed with the one. So this is similar to the SQE situation. There can only be one correct answer. Now, the way to think about this is like this. The one correct answer is not the fantastic, absolutely correct, all-encompassing correct answer. It is the best possible out of a bad batch. Yeah. So you're not looking for one absolutely correct answer amongst a bunch that are complete nonsense. It could be that all of them are partially correct or they look partially correct, but one is going to be slightly better. It doesn't have to be perfect. It doesn't have to be, you're not looking for the perfect answer. You're looking for an answer that gets the closest. So out of the 5, you're going to have one that is technically correct and is the closest. You're going to have a couple that kind of look right, but they don't match. There's something wrong with them. Either they kind of misunderstand the facts a little bit, or they mistake the law a little bit, or they're kind of slightly off. And then you get another 2 that tend to be a little bit further off. They're kind of wrong for more significant reasons, either a more obvious misinterpretation of the facts or a kind of different legal area that they're picking up or something like this. But that's why this is a difficult task. It's not getting the one screaming perfect answer amongst those that are really, really wrong. It is getting the most plausible one amongst a group that have the possibility to answer this question. And we can legitimately disagree. Very often when we're having these live streams, I'm telling you, I don't like these answers, because it genuinely looks like more than one could be correct, or it genuinely looks like none of them are correct. But the task is to pick one. We have to come out with one winner no matter what. And you, unfortunately, do not have the time to second guess yourselves, because you're meant to make this determination, read everything, make up your mind, pick the correct answer, move on in less than 2 minutes, okay? You have to work this in a sort of methodical, mechanical, rapid way. Otherwise, you're not going to have time to finish. And even if you don't know at all what the question is about or what could be the possible answer, just pick one at random and move on. You're likely to lose more time fretting over it and agonizing over it when you don't really know the answer. This is more likely to be damaging for you than just picking one and moving on and making sure you get the next one correct. Okay? So this is all about what can you do with losses and whether you can carry forward to a next tax year losses, and what also happens with allowances. So the answers here can be found in the tax rules. Every year you get an annual exemption, right? You don't pay tax up until amounts of a certain level, right? These are simply for the year. They don't compound. You cannot carry them forward. You cannot take them with you. You cannot apply those exemptions to the next year. In exactly the same way that as personal allowance, if you're an individual taxpayer, you're not asked to pay tax on the first £12,000 that you make. But that's, only for this year. You cannot say, I didn't earn anything this year, therefore I'm keeping those £12,000 that I didn't have to use this allowance and I'm taking it to next year. So next year I've got 2 times 12,000, so I don't have to pay the tax for the first 24. That's not how it works, okay? So any annual exemptions or tax allowances you've got, they're only relevant for the tax year that you're looking at. However, losses are not the same. So losses, sometimes you can carry them over, and sometimes you can carry them over indefinitely up until you get to use them. So when you use those losses against income that you earned that year, then that's it. It settles at that point. And then the next year, everything refreshes. But for capital gain losses, you can actually carry them with you indefinitely till you get to the point that you generated the income that you can set them off against. That is only the capital gains losses, okay? This is not the annual exemption. So with this in mind, if we read the questions, the only one that is correct is option E. Option E says she can carry forward her £2,000 losses indefinitely until she has an opportunity to use them and cannot carry forward her 24-25 annual exemption at all. Okay? So that is the correct answer, because that understands that capital gains losses can be carried forward forever till you get to the point that you use them, but also contains the acknowledgement that any exemption only applies for the year that it's in and cannot be compounded, carried forward, or anything like this. So the only option that gives us this is E. All the others are confusing it by either getting one bit wrong or getting the other bit wrong. Okay? So I don't think there's any point in me kind of going through them one by one, because they just offer different mistakes either on the treatment of the capital gains loss or on the treatment of the annual exemption. The only one that gets both components correct at the same time is option E. All right. You guys like tax questions? I don't think anybody likes tax questions. I've got a couple of videos published already that deal with tax implications. I've got one specifically on business tax and the treatment of business tax. I'm developing the material I've got on taxation to include personal taxation, because that I haven't covered very fully. I'm also doing some work on inheritance tax and all of that stuff. So all of that is in the queue of things that I'm preparing for you guys that are going to publish and become available on the channel for you sooner or later. Okay, so that was question 66. Shall we try our luck with question 67? Okay, now question 67. A woman, the claimant, instructs a solicitor to issue a claim for damages against a firm of financial advisors, the defendant, on the basis that it provided her with negligent advice when she was its client. The claim is valued in excess of £100,000. The defendant, these are the financial advisors, right, instructs a solicitor, and the defense is filed and served. On the same day that the defense is filed and served, the defendant's solicitor makes a Part 36 offer of £125,000 on behalf of her client. The relevant period for acceptance of the offer is 21 days. 1 week after expiry of the relevant period, the defendant's solicitor meets in conference with counsel to discuss the case. 2 weeks after the expiry of the relevant period, the defendant's solicitor receives a letter from the claimant stating that she no longer has solicitors acting on her behalf. Her letter also includes notice of acceptance of the offer, with confirmation that her notice of acceptance has also been filed with the court. Okay. Which of the following statements best describes the most likely cost consequences in the case? Okay, so let's take this from the top. So the firm of financial advisors is served. Okay, they initially make a settlement offer. This is what the Part 36 offer is about. So this is a settlement offer. But as you know, if you've gone through my video on civil procedure, I've got a couple of videos that are addressing dispute resolution, which is effectively the procedure in the civil courts in England and Wales. Part 36 offers, settlement offers, have got time limits that they need to be accepted within those time limits. Now, if you don't accept them, or if you accept them late, then this has consequences on the amount of costs and who gets to pay those costs and how they're calculated. So this is the area where we're at. Again, a difficult area of the law, especially if you are used to kind of more theoretical treatments of those issues. If you're a recent law graduate and so on, you don't really get into the nitty-gritties of these calculations. So this is more the the kind of legal practice course level material, or something that you're gonna come across in the context of your SQE prep, but you are unlikely to have seen in your law degree. Perhaps if you practice, you see these things, but if you're in a law firm already, but certainly unlikely to have seen this in the law degree. So question was, which of the following statements describes the most likely cost consequences in the case? Is it A, the claimant will pay the defendant's costs of the case on the standard basis? B, the claimant will pay the defendant's costs of the case on an indemnity basis? C, the defendant will pay the claimant's costs on the standard basis to the expiry of the relevant period, and thereafter the claimant will pay the defendant's costs on the standard basis. Okay. The defendant, D, the defendant will pay the claimant's costs of the case on the standard basis, and E, the defendant will pay the claimant's costs on the indemnity basis to the expiry of the relevant period, and thereafter the claimant will pay the defendant's costs on the indemnity basis. Now, a couple of things. First of all, why are we switching between the defendant's obligations to pay and the claimant's obligations to pay? Obviously, who wins the case is important as to who has liability for costs and how they're calculated, but also settlement offers sometimes switch those directions, because the idea is if you're made a settlement offer and you don't agree to take it, and then you proceed in trial, and then you got a worse outcome in trial than the settlement offer, then you are faced with costs penalties because you wasted the court's time. That's why you can have these reciprocal obligations to pay the fees, and they switch. Part of it goes to the solicitor, part of it goes to the claimant, part of it goes to the defendant. It is not simply a matter of who won, but it is a matter of who won in relation to what settlement offer was available and what happened when considering that settlement offer. So that's one thing to keep in mind. I admit this is complicated, but it's there. The second is the ability to distinguish between standard and indemnity basis for the calculation of damages. Now, standard isn't great, but that's what normally happens. It means that if you have reasonable and proportional costs, then you get those reimbursed by the losing party to a degree. So you don't get all your money back if the costs assessment is on the standard basis. The indemnity basis is better, because on the indemnity basis you have better chances of getting closer to full disbursement, that your entire cost is covered. But indemnity basis is unusual. You get it when people have behaved unreasonably, or where they've been abusive, or when they pissed off the court by not participating in the process in a way that the judge has demanded. Now, it is possible that you get your costs assessed on an indemnity basis, but it is not very common. The standard is more common. Now, with all this in mind, with the kind of flip-flopping between claimants and defendants' obligations to pay costs, with knowing the difference between standard and indemnity, do we have any thoughts as to what might be the correct answer here? It's a tricky one. So if I had to pick one, and if I was sitting the SQE, I would need to pick one. That's the name of the game. I would choose C. So at the same time as I said it, one of your colleagues put it in the chat. Thank you very much. It is C. Why? Because we're going to have to look at the rules in the Civil Procedure Rule 36, and then we're looking at section 13.4. So we're looking at part 36, and we're looking at section 13.4. C says the defendant will pay the claimant's costs on the standard basis to the expiry of the relevant period, and thereafter the claimant will pay the defendant's costs on the standard basis. The reason for this is that they failed to accept the settlement offer within the time frame, but they accepted the settlement offer thereafter. Okay? So the relevant period will be the expiry date of the settlement offer. Now, why are the rest wrong? Anything that says indemnity is wrong. So B and E that mention indemnity are wrong because this would not be relevant in the calculation of the costs here. A that says that the claimant will pay the defendant's cost of the case on the standard basis is wrong because it doesn't take into account the time frames in relation to the settlement offer. D again is the mirror image of A and is wrong for the same reason. So the only one that has calculation on the standard basis, but also takes into account the shift in relation to the acceptance of the settlement offer and the time frame that was attached to this, the only one that does this is option C, and that's why this is the correct option. Now, I find this a difficult question. The reason is that, civil procedure isn't something that I'm like 100% comfortable with. Every time I look at that stuff, I need to read a little bit extra, go back to the CPR, have a think about the rules. So it's not my area of comfort. However, it is something that features prominently in the SQE. It's something that we see all the time in the MCQs, in the samples. And considering that you guys have to kind of go on and survive SQE2 as well, a good grounding in the civil procedure rules and what the process is for things like this would be a good investment of your time. Because sometimes I know that the set of what we do here is focused on SQE1, but we need to anticipate what's going to happen in SQE2 as well. So a deeper understanding of procedures and processes and what happens with this stuff would be handy for your prep looking forward. And I'm confident that all of you guys are going to ace SQE1, and then you're going to have to put all your worry time into SQE2. Yes? How are we feeling? Are we feeling confident? Give me like a kind of happy emoji if you guys are feeling confident about the January sitting of SQE1. Yes, we can do it. We can have a great Christmas, and then we're going to launch into the new year ready to succeed and prevail in SQE1. Yes. And if you guys love, because I know there's one thing you love, right? Everybody loves MCQs. I know you love MCQs so much that you just cannot have enough. That's why you're coming to my live streams. That's why you're watching the replays. That's why you're kind of going and purchasing additional sets of questions or signing up with prep schools or buying the books from Revise SQE with the questions. I know that you guys are crazy about MCQs. And because I want to contribute to your efforts and to fuel your passion for additional MCQs, I can email you one every Monday. So if you subscribe to my newsletter, so it is newsletter at glintis.co.uk. So if you send an email to this email address, write subscribe in the subject matter. You don't need to write anything else, right? If you do this, I will add you to my mailing list. And every Monday, you will receive an email that's got a fresh, not SRA sample, a fresh, created by me, fresh MCQ. It's also going to give you the previous week's MCQ with a full explanation like we do here in this live stream about why the correct answer is correct and why the wrong answers are wrong. It's also going to give you reading material or relevant videos to watch depending on what the topic of the week is. Then it's going to give you other tips and tricks. It's going to give you discount codes for relevant services and products you might want to purchase, all of that stuff. And even better, all of this is free. So you're going to get your free edition of the newsletter every Monday forever. Yeah, forever and ever. I currently this week I sent out newsletter 115. Yeah, can you believe that? For 115 Mondays, I've been sending out this newsletter. So I am nothing if not consistent. Yeah? Yes, thank you. Yeah. Okay, let's look at our next and final question for today, which is question 68. And finally, we're going to finish with a slightly more pleasant one. I think it's a topic that I actually know something about. Now, question 68. A self-employed builder who wishes to buy goods from a building supplies company contracts a solicitor for advice about the one-page written contract that the company has sent to him. The reverse of the contract states the company's standard written terms of business. The builder has been asked to sign, date, and return the contract to the company if he wishes to use the company to supply goods. The builder has received no other communication from the company. The solicitor reads the contract, including the terms shown on the reverse. He correctly states that the terms have been incorporated, but identifies that one of the standard written terms of business seeks to exclude a type of liability that cannot be excluded under any circumstances. Which of the following terms is the solicitor referring to? So, this is a long-winded question with actually a great deal of misdirection, because it's telling you about incorporation of terms, it's telling you about the things being at the back of the paper. You might be thinking as you're going through it, is this a question about incorporating contract terms? Is it a question about some sort of exclusion clause? Is it a question about notice? What's going on here? But it's giving you all these options with a slightly different twist. It's telling you that the solicitor has already identified something that is wrong. Okay? So we need to figure out, so this is not a question as to whether the terms are incorporated correctly or not. This is a question as to which one of the incorporated terms is not going to work. So your options. Which of the following terms is the solicitor referring to when he says that this is a type of liability which cannot be excluded under any circumstances? Is it A, exclusion of liability for misrepresentation made by the company before the contract was entered into? B, exclusion of liability for breach of the statutory implied term that the goods would be fit for a particular purpose? C, exclusion of liability for breach of the statutory implied term that the seller has title to the goods at the time of sale. D, exclusion of liability for breach of the statutory implied term that the goods supplied will be of satisfactory quality. E, exclusion of liability for breach of the statutory implied term that the goods sold by description will correspond with that description. Aha. So, what do you guys think? First of all, what are all these? Why would you assume to have all those rights? Okay, because all of those are implied, they are rights that are contained in implied terms that are coming from the Sale of Goods Act. Why the Sale of Goods Act? Because this is a business-to-business transaction. So we've got a self-employed builder who buys building material from a building supplies company. So even though you must be thinking, there is the Consumer Rights Act that's got similar things, this isn't it. Because in a business-to-business contract, our correct reference is the Sale of Goods Act. Now, the Sale of Goods Act contains a stack of implied terms in its provisions, starting from 12 about having the right to sell, then moving on to 14 about fitness for purpose, quality, and all of that stuff. Then we got others about matching description and so on. Now, the question becomes, are you allowed to deviate from those implied terms under the Sale of Goods Act? Now, you wouldn't know simply by looking at the Sale of Goods Act. You need to go a step further. And the step further is the Unfair Contract Terms Act of 1977. And the two work together. The Sale of Goods Act is telling you what rights you have, what are the implied terms that are coming into those contracts, and the Unfair Contract Terms Act tells you the extent to which you can deviate from those implied terms and what is the process that you need to follow to be able to do so. And this is different, even though it talks about similar situations, this is different from what happens under the Consumer Rights Act. So be very careful with this. You need to determine at the very beginning whether you're talking about a consumer contract or whether you're talking about a business-to-business contract. So having this in mind, we're talking about implied terms that are coming from the Sale of Goods Act, and then thinking about the procedure that the Unfair Contract Terms Act has in place to check whether it allows or does not allow deviation from those in the form of exclusion or limitation of liability. Which option would you pick? Which one did the solicitor think that he thought immediately is, that one is wrong, because you cannot exclude this on the basis of the Unfair Contract Terms Act. Now, luckily, if you guys did the law degree, and perhaps not very recently, maybe a few years back when we used to spend more time on this stuff, then you will know what the correct answer is. Okay. Because I've definitely spent a great deal of time teaching this stuff to my contract law students. Okay, the correct answer, ladies and gentlemen, is C. The term that the solicitor is referring to, that this is a type of liability that cannot be excluded, is liability for breach of the statutory implied term that the seller has title to the goods at the time of sale. Because the Unfair Contract Terms Act says that this obligation cannot be excluded. You are not allowed to put a term in your contract that says the stuff that I'm selling you, maybe they're mine, maybe they're not, and I'm not going to be held liable if they're not. This is an absolute prohibition. Everything else could be allowed if it satisfies the requirement of reasonableness. The requirement of reasonableness is in Section 13 of the Unfair Contract Terms Act of 1977. And then you look at an appendix that they've got a schedule. The schedule gives you a mechanism to apply this reasonable test. It has to do with whether other people in the industry do it, whether you knew about it, whether you received an incentive like a discount in order to agree to that clause, whether you've done business with these people in the past and you're familiar with the clause and its operation, that sort of stuff. So option A that talks about misrepresentation, yes, liability for this can be excluded. The Misrepresentation Act allows it. The Unfair Contract Terms Act allows it as well. Exclusion of liability for fitness for purpose, quality, and match with description, that are your options in B, D, and E, can also be excluded if it is reasonable in the individual circumstances. It doesn't mean that they can always be excluded and it's fine. You need to look at the individual circumstances and run the reasonableness test. But if that's the case, then it can be done. The only one that's an absolute no-no is exclusion of the obligation to have title to the goods that you're trying to sell. Another one that you might remember from previous questions that we've done together, any attempt to exclude liability for personal injury or death. It doesn't matter if it's reasonable, okay? You're not allowed to exclude this. There's an absolute bar to doing this. Excluding liability for negligence that results in personal injury or death. It's an absolute no-no under Section 2 of the Unfair Contract Terms Act. So the correct answer for our final question, which was 68, is C. You cannot exclude liability for not title to the stuff that you're selling. A motorist negligently causes a collision with another car which is driven by a woman. As a result of the negligent collision, the woman suffers several losses. She suffers serious hand and arm injuries which will require extensive physiotherapy. The woman intends to pay for private physiotherapy as the waiting list on the NHS is many months long. Her car is badly damaged and requires substantial repairs. Her laptop is on the passenger seat of the car and is damaged beyond repair. The woman uses the laptop for business purposes. The woman's antique engagement ring, worth £10,000, is destroyed in the accident as the diamonds in it shatter with the force of the collision. The woman brings a claim in negligence for all these losses. The motorist accepts liability for the car collision, but disputes the quantum of damages. In addition to liability for the personal injury and the damages to the car, what other losses is the motorist liable for? Here are our options. A, the woman's private physiotherapy treatment, her laptop and antique ring. B, the woman's private physiotherapy treatment only. C, the woman's antique ring and laptop only. D, the woman's laptop only. E, the woman's antique ring and private physiotherapy treatment only. Now, before you say this sounds weird, like the woman and the man and so on, and that kind of sounds weirdly sexist, this is how the SRA has instructed us to write the questions. I mean, I know that this is their sample, but when we're writing our own questions as well, and when the prep schools are, we're following this pattern. They said to keep it to keep it generic and not give names. That's why it's always the solicitor, the man, the woman, the client. I don't know what to say, okay? This is their style, so that's why we're doing it this way. So, out of the 4 people we got watching us live at the moment, who is going to be brave enough to venture a guess? What are you voting for? Remember, the motorist accepts liability, and he accepts liability for personal injury and the damage to the car. But it's the other losses that he wants to challenge. So are we going for everything that is A? Are we going for just one of the more limited options available there? Now, clearly, the topic of this question is the law of tort, and we're thinking about compensation for negligence. This is a kind of car crash situation, so the duty of care here is statutory. There's definitely been a breach, so we don't need to be concerned as to issues of liability. We just need to be concerned about how far can we take the losses. And the 2 tools that we've got available to help us distinguish from recoverable and non-recoverable losses are the doctrines of remoteness and mitigation. So for you to be able to claim for some loss that you've suffered, it needs to be causally related to the breach, of course, because if it is irrelevant, you cannot claim. But even if it is causally related, it needs to be within the rules of remoteness, because it's possible that some stuff are causally related, but they're so far distant that they don't merit compensation. So that's one of the limiting doctrines are causation, remoteness, and mitigation is your obligation, the obligation of the victim to contain their losses. Okay, easy example is if in breach of contract, the taxi that's taking you to the airport does not arrive, then you need to find a way to go to the airport. Then you take the tube or you take another taxi. If you take a private helicopter to take you to the airport, which sounds nuts, and it's going to be terrifically expensive, then you would not expect the person responsible for your loss to cover the entire extent of the bill of the helicopter. So that's the doctrine of mitigation. Now, with all this in mind, what do we think the woman is going to be able to cover? Now, the SRA's answer for this is A. The woman will be able to claim for private physiotherapy, her laptop, and the antique ring, in addition to the damage to the car. So she's able to bring a claim in negligence and be compensated for all these losses. Now, if this sounds surprising, because it might feel like too much, think about what we're trying to compensate for. This is tort, this is not contract. So in fact, tort is more liberal in the things that you can claim. If it is reasonable for her to get the physiotherapy on a private clinic as opposed to the delays that she would suffer if she was on an NHS list, then this will be compensated. Reasonableness is going to be assessed on an objective standard by the court at the time. So if she said, I just prefer a private clinic, that wouldn't be enough. But if she says she wouldn't be able to get adequate treatment within a relevant time frame on the NHS, then that would be sufficient to pass on the cost of the private treatment. So long as it's reasonable, she can get the physiotherapy. Now, both the laptop and the antique ring are consequential losses that arise out of the breach of duty, out of the negligence of the other motorist. Therefore, they are compensated. This is not a situation that they need to be within the contemplation of the other party, because in the law of tort, you can cover consequential losses. And if you remember the thin skull rule that said you take your victim as you found it. So the fact that she was wearing like a very delicate antique ring is not going to count against her, since it is the fault of the motorist to begin with. So the correct answer here in this question, that is in the law of tort, that is about negligence, that is about assessment of losses and the quantum of damages in negligence, the correct answer is A. She can claim for all of it together. So, well done to the lady, and commiserations for the trouble that she's been in. Okay, if you guys are happy with this result, give me some sort of emoji or hit that like button to show, I don't know, to show how you co-suffer with the victim. Yes. Okay. Alrighty. So we are now moving on to question 70. Yeah. Again, a woman works for a charity for disabled people. The main function of the charity is to arrange transport for disabled people in and around the community. The charity uses one particular firm of taxi drivers to carry out this function. The woman reads in a newspaper about recent legislation which requires taxi drivers to help disabled people when using their taxis. The woman looks up the legislation and finds as follows. Taxis and Private Hire Vehicles, Disabled Persons Act 2022, Chapter 29. It is an act to make provision related to the carrying of disabled persons by taxis and private hire vehicles. And in brackets, it's got the date 28th April 2022. The woman wants to know what is the significance of the date and telephones. Imagine the charity's solicitor for legal advice. Now, I gotta tell you guys, I know that this is the SRA sample, but this is such a highly unrealistic scenario. It really kind of baffles me. Who in their right minds is going to call the solicitor that probably bills them by the hour, and the hour costs anything above the first 5 minutes, okay, in order to ask such a mundane question? Why didn't she just ask ChatGPT like a normal person? I don't know. Maybe these questions were written by our friends at Kaplan a long time before ChatGPT or Google came along. But yeah, so this isn't. If you're in charge of a business and you've got a lawyer on the retainer, do not call them with this type of question. Okay, you're gonna pay £300 for something that ChatGPT could have told you in an instant. But we're doing this for different purposes. The question, therefore, is: what would the solicitor advise? Your various options are: A, it is the date the most recent draft of the statute was presented to the House of Commons. B, it is the provisional date for the statute coming into force. C, it is the date the statute received royal assent. D, it is the commencement date of the statute. E, it is the date on which the statute passed the committee stage in the House of Commons. So you see, you didn't see that coming, did you? Because you got a question about disability, you got a question about charity, you're thinking, oh, this got to do something about human rights, this, that, or the other thing. Nope. The question is completely randomly about the legislative process. There you go. This is an outlier right there. So would anybody like to venture a guess on what is the significance of the date of the 28th of April 2022? Yes. Now, as you're thinking about this, might be a good moment to say, this is what your average SQE question looks like. You got a rather chunky scenario that goes on for a few sentences, so it's like a paragraph's length, and then you got 5 possible options. Out of the 5 possible options, there's only one correct answer. You guys are a fan of the Lord of the Rings? Well, it's just that there can only be one. Same stuff with the SQE. There can only be one correct answer. So your job is to find the answer that is the best out of the set available. This means it might not be perfect. It just needs to be better than all the rest. So you're not looking for perfection. You're looking for the best possible match. Out of the 5 that you got, it's very likely that you're going to get 2 or 3 that look close and a couple that look wrong, either on the facts or on the law. From the ones that look the closest, as I said, you're not looking for one that's absolutely perfect. You're just looking for the one that is a little bit better than the others. Yeah. I mean, to be honest with you, this one's dead easy because there's only one actually correct answer here. All the rest are like just wrong. So who would like to venture a guess as to which one is the correct one? If you don't do it quick, I'm going to give you the answer. So the answer, ladies and gentlemen, is C, is the date the statute has received a royal assent. Okay? This is the date that you get noted next to the, yes, Laura is there. Thank you, Laura. Yeah, you got it right. C, the date that you see next to the statutory information is the one that gives you the date that it became law in the sense that it received royal assent. Be careful. It doesn't mean that the act is in force. Okay? It could be that it comes in force later on, and there's going to be more information about this. The date itself means when it finished its legislative journey by receiving royal assent. All the other possible answers on this are just wrong. Okay? There we go. So, was this a good spend of the woman's legal budget? Absolutely not. But I'm guessing that's why we do the SQE, so we find these things out, and then we don't fall into the same traps ourselves. Okay. Are we ready for our next question? Question 71. A paralegal is employed by a firm of solicitors, which is authorized as a legal services body. The paralegal has not worked in a solicitor's firm before and has no other relevant work experience. Well done on bagging that job. She works in the Civil Litigation Debt Recovery Department, and her work is directly supervised by a practicing solicitor in the department. Will the paralegal be subject to regulation by an approved legal regulator? Aha. Right. Let's see what are our possible options here. A says yes by the Solicitors Regulation Authority. B says yes by the Legal Services Board. C is yes by the Law Society. D is no, as a paralegal she's not subject to regulation. E says no, as she's directly supervised by a practicing solicitor. All right. So this question is on the topic of solicitors regulation. This is again pervasive throughout the FLK. You got specific information on the conduct of solicitors and on the expectations, but these things can tend to crop up also linked up with other areas of the FLK. So I would pay attention to the obligations of solicitors as you're going through your material. You know what, especially if you've got no experience in practice, you're not yourselves a paralegal or something, because if you've simply done an undergraduate law degree, we tend not to really talk about the SRA and solicitors' obligations and the professional requirements. So if you're a recent graduate without a great deal of work experience, this might be an area that you are very unfamiliar with. So I would suggest that we pay a bit of attention to this. So the question again is, will the paralegal be subject to regulation by an approved legal regulator? Okay. Now, we know that the SRA is the regulator for the solicitors. So that's pointing us in one direction. Now, does anybody know what is the Legal Services Board? This is not the regulator. This is the oversight body of the sector, but it is not the one that directly regulates law firms. So it cannot be the Legal Services Board. Also, it cannot be the Law Society, because the Law Society itself is the representative body of solicitors, but it is not the regulator. So we've eliminated B and C. What about D and E that say no? Well, a paralegal by themselves that is not working in a law firm will not be subject to regulation, because being a paralegal is not, you don't have a practicing certificate, you're not subject to the regulatory authority of any relevant body. But this isn't simply a paralegal working in a corporate environment. It's a paralegal working in a law firm under the supervision of a solicitor. For that reason, she will be subject to regulation through the SRA. So the correct answer here is option A, that says yes. Will the paralegal be subject to regulation? Yes. And what is the approved legal regulator? It will be the Solicitors Regulation Authority. So correct answer here is answer A. So why is that? It is not because paralegals by themselves in isolation are regulated. It's because the law firm that she's working for is regulated, and the solicitor under whose supervision she's working is also regulated. Now, pay a little bit of attention in this area for different reasons as well. There's been recent case law that kind of puts more stringent requirements in the regulation of law firms. Law firms got into trouble by having a lot of regulated work being done by people who were not themselves solicitors. So it is not possible anymore to offload a great deal of administrative style tasks to paralegals and other support staff without the supervision of a solicitor. So these things are changing a little bit. Perhaps they had gotten a little bit too loose after the liberalization of legal services. Now the SRA is making a point of bringing things a little bit back and making sure that if anybody within the chain is carrying out a regulated activity, then this is always done under the regulation of a solicitor and not independently carried out by people who are not qualified or AI tools or anything like that. Yeah. So correct answer to question 71 is option A. Let me move on my screen for the rest. Okay. Did any of you attend any of the kind of long broadcasts that I did over the last few days? There were quite a few people watching them and chatting in the using the chat to interact with me. So I think that worked well. Right. You see, this is like the source of innovation. Like every week, I'm thinking of something new to do for you guys. By the way, if you guys love my efforts and you would like to support me, you can become paid members of the channel. And because of inflation and the general deterioration of economic conditions, I'm getting cheaper by the day. So I started off as $2.99, which was the price of the cheapest coffee you could find in London, but I don't think you can find a coffee for $2.99 anymore. But what you can do for $2.99 is become a paid subscriber to the channel, which will give you the opportunity to see all the videos I've got queued up straight away, to participate in certain members-only live streams that I'm doing, and generally give me a gift for Christmas. And incidentally, give YouTube a gift for Christmas as well, but that's another problem. So yeah, there we go. So we've got the option to become paid members of the channel if you want to do this. If you don't, it's not a problem, and you're gonna get to see all the videos eventually because they're all on a schedule and they're publishing. The latest one that I uploaded yesterday is a fantastic one on criminal law. It is on FLK criminal liability. and it takes you through all the basics of the organization of criminal law and all the key concepts that you need to know. And I've illustrated with like a fantastic little movie at the beginning about the people who cut down the sycamore tree. Do you remember this? That a bunch of kind of drunken idiots, they went down and cut like a very famous tree, and it became like an issue. Well, these guys got sent to prison for 4 years this summer when they got convicted. So I'm starting off the criminal liability lecture with that story as an example of what happens when you breach the criminal law, and then it goes on from there. So I'm really proud of it. I think it's an awesome video. So let me know what you think when you see it. Okay, so question 72. A new firm of solicitors is voluntarily registered for value-added tax, VAT, and makes only standard rate supplies. This means like the 20%, yeah? During the relevant VAT period, it charges output tax of £10,000 on its services, and it pays input tax of £20,000 on goods it buys for the purposes of its business and on its heating bills. Which of the relevant statements best describes the firm's position at the end of the relevant VAT period? Now, if you guys haven't spent a lot of time doing tax law, this probably sounds like gobbledygook, yeah? But unfortunately for you and for me, tax is part of the FLK. So we're going to have to study that stuff one way or the other. It's not the easiest thing. If you're in business yourself, so if you're like if you're running your own private limited company, or you're a sole trader or entrepreneur, you probably have come across these things in real life, which is certainly going to be helpful. But if you haven't, if you're kind of straight out of uni with no business of your own, you're going to have to study some of the tax rules in order to prepare yourselves for the SRA exam. And not only tax in relation to business taxation, but tax also in relation to personal taxation, which makes things even worse. Right, so let me try and unpack this a little bit, because there's a lot of concepts here. So we're talking about VAT, right? This is the kind of thing that gets added when you buy something retail. What is standard rate of VAT? That's the traditional 20% that goes on the majority of goods and services. There are special categories of VAT as well that might be reduced, and you've got some categories that don't charge any VAT at all. So there's a lesser VAT on books, on some food supplies, some stuff like that. There was an argument recently as to whether the roast chickens, you know what I mean, yeah? The rotisserie chickens that you buy in a bag at the supermarket already roasted, I mean, they're cold by the time you buy them, but should they count as hot food or should they count as cold food? And the source of this debate is that there's a different rate of VAT charged depending on whether it's hot food that you buy or whether it's cold. So HMRC took Sainsbury's to court over this. So it turns out that the rotisserie chicken that you buy from these kind of dingy looking bags in Sainsbury's, even though it is stone cold when you buy it, it still counts as hot food for VAT purposes. Who knew? Maybe you should roast your own chicken. Okay, so that's standard rate, means a standard rate of VAT. So output tax on 10,000. What does that mean? It means that it charged its own clients, yeah? It added VAT to the invoices the company sends to its own clients. It's also paid input tax of 20,000. This is the VAT that was charged on the things that the company was buying, okay? So the £10,000 is VAT that it charged other people. So it collected that money on behalf of HMRC, and the 20,000 is VAT that was paid outwards. Okay, are we okay with this? I mean, I do appreciate that if you haven't studied this at all, it sounds super weird. So the question is, which of the following statements best describes the firm's position? A, the firm does not have to pay any VAT and cannot reclaim any from HMRC. B says the firm can reclaim 10,000. C says the firm can reclaim 20,000. D says the firm must pay 10,000. And E says the firm must pay 20,000. Okay. What is the point of being VAT registered? You will take the amount of money that you collect on behalf of HMRC. So when the company issues an invoice, it says there's £1,000 for my services and 20% VAT on that, £1,200. So they pay me £1,200, but I'm keeping the £200 aside to return to the revenue. That's the tax. On the stuff that I pay out, clearly, they've done the same to me. So on their invoices, they had included VAT. That's the input VAT and the output VAT, right? So in order for me, if I'm VAT registered, I can ask for a rebate if the amount of VAT that I've been paying out is in excess of the amount of VAT I've been charging my own clients. So the way to calculate this is to take your input VAT and deduct from that your output VAT and then see what you end up with. That's the calculation, okay? So you start from the amount that you paid other people. You deduct from that the amount that you collected on behalf of HMRC. If you end up with a positive number, so you paid out more VAT than you charge your own customers, right? Then the revenue will return the money. That is the difference. If you have charged more VAT in your invoices to your own clients than the one that you paid to other people, then it works the other way around and you owe the revenue money. So if you're wondering, does it make any sense to be VAT registered? Yes, it does if your inputs are very expensive. So if you're buying a great deal of stuff to be able to run your business, but you don't actually invoice your own clients that much, so you've got a great deal of expenditure and limited income, limited turnover, then you might be able to recoup some of the VAT that you were paying when you were paying your own suppliers. But if it's the other way around, if you've got high turnover or if you've got really high margins and very little expenditure, then there's no point in being VAT registered if you can help it, because you always have money then to return to HMRC. So if you're earning a lot of money, but you have very little expenses and you're charging VAT, you basically become the middleman that collects the tax on behalf of the revenue to send it over to them. So why would you do this? Now, by the way, you're not obligated to register for VAT unless you're turning over £90,000 and above. So if that's what you're managing with your own business, well done. Then you need to be VAT registered. If you're below that threshold, then you could register voluntarily if you feel like it, but you don't have to. Okay. So hopefully that gives you guys, I do appreciate it's complicated, and I do appreciate that people who study law normally suck at numbers, yes? But hopefully this gives you a little bit of context. Right, so how are we gonna find the correct amount? We're gonna take the input tax. So this is what they paid when they were buying stuff, okay, which is 20,000. And we're going to deduct from that the output tax, which is what they were putting in their own invoices. So 20 minus 10 results in 10,000. So the correct answer is B. The firm can reclaim £10,000 in VAT. Again, why is that? Because the firm has paid a lot of VAT to its own suppliers when it was buying stuff from them, but it charged very little in the invoices it was giving out to its own customers. So that imbalance means that it's got the possibility to reclaim money from HMRC. You deduct 20 minus 10 results in 10,000. This 10,000 it can reclaim from HMRC. What a great business these guys have, that they're kind of having incredible expenditure, but they're all actually having that many customers of their own. Who knows? Maybe they're an AI firm and they're kind of building data centers, so then they can, make a killing in the future. Who would know? Okay. All right. How are we doing so far? By the way, are you guys loving SQE MCQs? Because if you're dying to have more MCQs to do, I've got a solution for you. You can subscribe to my newsletter by emailing subscribe to newsletter at glintis.co.uk. I just put it in the chat for you guys. And I'm going to add you to my mailing list. It's completely free for everybody. And every Monday, I'm sending you a fresh multiple choice question, some reading material or a video to watch that is related to the topic of the question, so to help you with your background understanding, a set of kind of either tips or discount codes for things that I find interesting, or ideas on products and services that you might benefit from, and a full explanation of the previous week's question. So you're going to get the question from the previous week repeated, and I'm going to have like a full explanation like we're doing here, why the correct answer is correct and why the wrong answers are wrong and all of that. So all of that comes every Monday for free on your inbox. So you can see all of that stuff. And these are always fresh questions that have not been released before, and they're not part of anybody else's set. They're the ones that are going to sit there and cook by myself over the weekend. Yes. So it's like, it's like Santa has a group of elves that are wrapping Christmas gifts. I don't, but I have a workshop where by myself I manufacture multiple choice questions for you guys. Yes, I don't wrap them, I just deliver them straight with the newsletter. So if you would like to benefit from this, completely free for everybody, email newsletter at glintis.co.uk with the word subscribe, and I'm going to add you in the long list of email subscribers that we've got already. Okay, great. How are we doing for coffee? I'm also almost reaching the end of my coffee for today. All right, now let's move on to our next question. Oh, and this is a chunky one. All right. Now, a solicitor. This is question 73 from the SRA's FLK1 set of sample questions. 73. A solicitor employed by a firm is acting for a client in the purchase of a new built residential property for £350,000. Contracts were exchanged a few months ago. The building works are finished and the completion date is set for next week. 6 weeks ago, a suspicious activity report, SAR, is correctly submitted online to the appropriate authority by the firm's nominated officer as a result of information obtained by the solicitor that the client is concerned in money laundering. Right. The SRA included the request for permission to proceed with completion of the purchase of the property. A refusal of consent to complete the purchase was received 5 weeks ago. There has been no further communication from the appropriate authority or any application by them to the court since. No action has been taken against the client or his assets, and the client has not been informed that he is under investigation for money laundering. Will the nominated officer commit an offense under the Proceeds of Crime Act 2002 if he gives consent to the solicitor to proceed with the purchase next week? Your options are A, yes, because the refusal to consent has been received. B, yes, because the refusal to consent has not been reversed within the following 31 days. C, no, because it has been more than 31 days since the submission of the SAR. D, no, because the client has not been informed that he's being investigated for money laundering and no action has been taken against the client or his assets. E, no, because it has been more than 31 days since the refusal to consent was received. Okay. Now, this is a complicated one, yeah? Again, we're in the area of solicitor's obligations and criminal law, because the obligation to be mindful of money laundering is a significant obligation on solicitors, especially as part of the conveyancing process. Now, interestingly, if this happens and they need to put a SAR in, they don't inform the client. Yeah. So if you've ever been involved in a property transaction and it dragged on and on and on and on, and nobody would give you an explanation as to why it's taking so long, one of the reasons could be that the buyer is being investigated for money laundering because they couldn't offer adequate proof of funds or something like this, and they triggered one of those investigations. So of course the solicitors know, but the clients are not informed. So let's have a look at the options and try and pick the correct one. What happens under the Proceeds of Crime Act 2002? Once the SAR is given, then the authorities have got 7 working days to investigate. During these 7 working days, no transaction is to be made. If the SAR returns with a refusal to proceed, then there is a 31-day moratorium during which the transaction cannot proceed. So here they had exchange contracts, right? So they cannot actually complete the sale during the moratorium period. They have to wait. Now, what happens at the end of the 31 days? So we've got the initial, the commencement of the process, but the issuing of the notice, then we've got 7 days for the authorities to make a decision. And then if they make a decision that stops the process for investigation, they've got 31 days for the investigation to run. Now, what happens at the end of the 31 days? If the solicitors haven't heard that the case is going to court and nothing else has happened, then the moratorium lapses and then the transaction can proceed. Yeah. If they have heard about progress in the case and escalation, then clearly the transaction cannot proceed. Here we are in a situation that the suspicious activity report has been made. That was 6 weeks ago. They received within the week, that's the statutory framework, the stop order. And from that point onwards, it starts running, yeah, for the 31 days. Now, we are already 6 weeks down the line. The 31 days have passed. The moratorium has lapsed. So now they're free to continue with the transaction. So the correct answer here is going to be the last option, E, where it says, so the question was, will the nominated officer commit an offense under POCA if he gives consent to the solicitor to proceed with the purchase next week? That is already like 6-7 weeks down the line. So the answer is no, he will not be committing an offense because it has been more than 31 days since the refusal to consent was received, and now the moratorium period has ended. The rest are wrong. A says yes because a refusal to consent has been received. No, the refusal to consent is only relevant for this first few days. Yeah, that's it. B, yes, because the refusal to consent has not been reversed. No, that's not how it works. So it's not like it's a permanent stop until reversed. It's the other way around. It's a moratorium period for 31 days, and if it hasn't progressed, then the moratorium lapses. C says no because it's been more than 31 days since the submission of the SAR. That's wrong. It's not the submission of the SAR that matters. Yeah, it is 31 days from the refusal. That's why you need to look in detail what it says in the relevant provisions of the Proceeds of Crime Act. D says no because the client has not been informed. That's irrelevant. Okay, as we said, they don't inform the client. So the options A to D are wrong, either because they kind of misstate the law or they just talk about something that's not directly relevant. The correct one is E, because it says so the person is not committing an offense if they proceed with the transaction because the moratorium has lapsed. A woman is given a new electronic tablet as a birthday present from her friend. Nice present. The friend bought it from a local retailer. The retailer was unaware that the friend was buying it as a present for this lady. When the woman comes to use the tablet, she's unable to switch it on because there's a fault with the power button. It's very depressing. The woman does not want to tell her friend that the tablet doesn't work because it's a birthday present and she doesn't want to make him feel bad. So she takes the tablet to a local repair shop where she gets ripped off, right? The shop repairs the fault in the tablet for £150, which the woman pays. The woman now is pissed off about this, and she wants to sue the retailer in negligence to cover the £150. Question for you guys. Can the woman recover the £150 repair costs in negligence from the retailer? Your options are no, because the defect in the tablet is unforeseeable loss. Yes, because the tablet was faulty. Yes, because the repair costs are consequential economic loss. No, because the repair costs are pure economic loss. Yes, because the retailer is strictly liable for the repair costs. Okay, what do we think? Feel free to venture a guess and put it in the chat. Don't worry about getting it wrong. This is a safe space. It's an even safer space because it's only the members in here, right? So your mom could not be watching this. I was kind of wondering, by the way, if like one of the people watching live is my mom, but it cannot be because my mom's not a member. So far as I can tell, you never know. All right. Are you ready for the answer? Do you want me to give you a hint? This is not a contract issue. It's a tort issue. Yeah. Now, if we take that as our starting point, that this is a negligence claim and this is a tort issue, the correct answer is D. No. So can the woman recover the £150 repair costs in negligence from the retailer? No, because the repair costs are pure economic loss. Now, this requires a bit of explanation. You would have thought in terms of consumer rights, in terms of, you know, sales and all of that stuff. But this isn't what's happening here, because here the woman did not buy the tablet. Somebody else bought the tablet and then gave it to her. We have a classic privity problem. You're in a contractual relationship with those to whom you provide consideration. So the person that bought the tablet is in a contractual relationship with the shop, and therefore has all contractual and consumer rights that arise from that relationship. So he would be able to take it back to the shop immediately and exercise his rights under the Consumer Rights Act. If he had suffered any additional losses, he would be able to claim from those following from that breach of contract. Because, of course, according to the Consumer Rights Act, buying something that doesn't work is a breach of your consumer rights, and it is a breach of an implied term that the goods are of adequate quality. But this is not what's going on here. The privity issue prevents the woman from bringing a claim in contract. So her only option is to bring a claim in tort. This isn't something to agonize over because the question explicitly tells you that she wants to recover these costs in negligence from the retailer. So even if you kind of got a little bit lost and kind of focused on the contractual aspect, because the question keeps repeating negligence, it would have kind of alerted you to the fact that this is meant to be a tort discussion and not a contract one. So the question becomes, can we recover for following on economic loss, financial costs and expenses if we're starting from a tort action in negligence? The answer is no, because in tort, you do not get compensated for pure economic loss. You can only be compensated for the direct losses that are consequential to the breach to the violation, in which case here would be the negligence that resulted in the tablet not working. So think of this as a car accident situation, right? If this is a car accident and you're suing the other person in tort, then you would be able to claim immediate follow-on expenses, medical bills and stuff like that, or the damage that was caused to your vehicle, but you wouldn't be able to claim purely for economic loss. Why? Because this is how the courts are distinguishing how far one can trace the losses, and this is a key difference between claims in contract and claims in tort. So why are the wrong answers wrong? A says no, because the defect in the tablet is unforeseeable loss. That's not the problem. Yeah, if you get something that is defective, you will have to fix it. So this is not unforeseeable loss as such. B says yes, because the tablet was faulty. Well, no, right? Simply the fact that it's faulty doesn't mean that you have a claim in negligence. C says yes, because the repair costs are consequential economic loss. Well, that's precisely the problem, right? If it is consequential, could work if it arises straight from the commission of the tort, but if it's pure economic loss, then it's barred. E says yes, because the retailer is strictly liable for the repair costs. That might be the situation if it was a contract claim, but not in tort. So, is this a difficult question? I don't know. You tell me how you feel about it. For me, it's difficult because it puts you in a mind frame that says contract, but then asks you a question about tort. If it was framed as a car accident, for instance, and you were simply thinking tort, then it would be easy for you to remember that you cannot get compensated for pure economic loss. It's the misdirection in the facts that might cause issues with this question. But overall, I don't think this is a terrible one. We're going to see some worse ones moving on. Right. So with your permission, I'm going to move on to the next one, which is question 75. Right. What is your favorite subject? Is your favorite subject contract or tort or business law? Or are you one of those weirdos that kind of fancy land law and property and all the rest? Yeah. There's always someone who says that they prefer property law for some reason. Is that you? Yes. If it's you and you're proud to like property law, equity and trusts, all of the FLK2 subjects, tell us in the chat and we'll make fun of you later. Yeah. Right. Question 75 from the SRA's FLK1 sample. A private limited company entered into a contract with another private limited company for the sale of 8,000 Christmas trees for the price of £160,000. The contract provided for interest at 7% per year to be paid for all overdue payments. The seller delivered the trees in accordance with the contract, but the buyer has not paid the price. The seller has complied with the necessary pre-action requirements and now wishes to issue proceedings against the buyer for the outstanding sums due and any interest on those sums. The seller's solicitor is drafting the claim form. Question for you guys. Which claim for interest should be included in the claim form? Is it A, interest at 8%, according to Section 35A of the Senior Courts Act 81 or Section 69 of the County Courts Act of 1984? Is it B, interest at 7% according to the contract? Is it C, interest at 8% over the Bank of England's base rate under the Late Payment of Commercial Debts Interest Act of 1998? Is it D, interest at 10% under Section 35A of the Senior Courts Act of 81 or Section 69 of the County Courts Act? Or is it E, interest at 1% over the Bank of England base rate under either Section 35A or Section 69? Okie dokie. Now, this is a process issue. So I don't know, where should we place this question? Should we place it in the kind of civil litigation dispute resolution domain? Probably, yeah. That is asking you about what happens when you've got contractual provision for the payment of interest for late payments, and how does this sit against the statutory provisions for the same, especially when the numbers differ. So were you to suggest the correct answer, which one would you pick? Do we need a drum roll for this one? The outlier here is the correct answer. So the correct answer is going to be B, interest at 7% per year under the contract. Now, notice something here. The standard way in which MCQs are presented for the SQE is that you've got like a fairly chunky scenario, and then you've got a series of 5 questions, out of which you pick one because this is a single best answer situation. When you're trying to find the single best one, you may notice that 4 of them are very similar in structure, but one is an outlier. Now, this means nothing because there is no predictable pattern that the one that doesn't follow the structure of the others and stands out is going to be the correct one or is going to be the wrong one. So sometimes they will stick a possible answer that looks different to all the rest just to distract you, to attract your attention, or to get you to think about it. Sometimes it might be the correct answer, sometimes not. Now, in this case, the one who looks different, the one that is shorter, is B, and that one happens to be the correct one. So if you don't know the substantive topic very well, don't necessarily look for clues in the structure. This could be accidental, or it could be made just to get you to think that way in order to confuse you. It's not like a hidden gift from the examiner to make the correct answer stand out. Clearly, if we're looking for a single best answer, we're not looking for a perfect answer, and we need to remember this. Yeah, it's entirely possible that none of the answers are particularly good. You just have to put them in order and say, I have to make a single selection out of these ones here, which ones are misrepresenting the facts of the question, which ones are misrepresenting the law, from the ones that seem more or less okay, which one comes the closest. So don't expect perfection. It's quite possible that the one that you pick is not going to be the possibly best answer that we would have written by ourselves. But the point of the exercise is not is the best from what you've got available, is not the best in the abstract. Okay, so let's try and remember this because that frames a little bit the discussion that we're having. If you've got contractual provision on setting interest rate for late payments, this overrides the default position that you're going to have through legislation. Yeah, I mean, in this specific area, this specific context, contractual provision of interest rates for late payments, this is what happens. So there is, of course, a mechanism in the statute to cover situations where the parties have not actually made a decision in the contract, but this is the default position. And when you've got a default position, but you've got specific mention in the contract, then the contractual provision prevails. That is the reason why, in this case, the correct answer is B, and the contractual rate of 7% is going to apply to any outstanding payments up until the point that they get paid. Yeah. So hopefully this answers the question for you guys. If you guys are enjoying the show, make sure that you tell your friends about it, and you tell other people that they can join the channel. They can join for free and have a look at all this free stuff that are around, or they can join the channel as paid subscribers like yourselves today and get the additional content and the special live streams. And if you want to even upgrade to the preppers version, you get the Substack FLK guides and all the rest of it. So if you got any friends that are struggling there and feeling lonely and they're looking for an online community to suffer with, then we can offer this through our interactions here on this channel. Shall we move on to our next question? There we go. Question 76. Right, let's see what this one's about. A solicitor is representing a client at an arbitration hearing, which will include the examination of witnesses. A legal representative acts for the opposing party in the arbitration. The client sees the representative speaking to a witness for the opposing party outside the hearing room. The client overhears the representative telling the witness what questions to expect during her cross-examination and the answers she should give to those questions. The client mentions this to the solicitor and instructs the solicitor to have similar conversations with witnesses giving evidence on the client's behalf. Which of the following is relevant to whether the solicitor is permitted to have such conversations? Is it A, the opposing party in the arbitration is engaging in such conduct? Is it B, such conversations will be subject to legal privilege? Is it C, conducting an arbitration is not a reserved legal activity? Is it D, such conversations may influence the substance of the witness's evidence? Or is it E, the solicitor has been instructed by the client to have such conversations? Aha. So the question here is a little bit peculiar, right? Which of the following is relevant to whether the solicitor is permitted to have such conversations? I can see what they were trying to do here, but I don't think that here, Kaplan has excelled itself in structuring this question. I think it's a little bit peculiar, and I think the potential options are also peculiar. Which one would you pick if you had to? And if you find this as part of your SQE1 exam, you're gonna have to. So, not disapproving of the question is no solution. Yes, you still have to pick one. Which one do you think would be the best? My suggestion, and to be honest, it's not just me, the SRA's suggestion as well, is D. Such conversations may influence the substance of the witness's evidence. Right? Now, the problem here is that there's a risk of influencing the witness and altering the evidence. If the lawyer talks to them, coaches them, instructs them what to say, we're getting very close to a situation that the solicitor is determining the evidence that the witness is producing. This is not allowed. So under the SRA principles and the code of conduct, you cannot coach the answers of the witness. You can talk with the witness and you can explain to them what the process is and you can tell them what to anticipate and so on. So, of course, if you bring in a witness, you need to kind of help them along to understand their obligations to the court, because their obligations are to the court, they're not to you, even if you're paying them. All of this needs to be made clear. So I'm not talking about coaching in the sense of explaining what the witness's obligations are. I'm talking coaching as in the witness just telling the court the information that you have pre-supplied to them. That's the bit that's not allowed. So if our question is, which of the following is relevant to whether the solicitor is permitted to have such conversation, I think the best possible, not great. I told you about this before. It wasn't going to be great, but we're looking for the best possible answer. The best possible answer is D, because that's the one that highlights the potential for violation of the SRA's code of conduct. How about the others? The opposing party in the arbitration is doing it. This isn't relevant because this is no excuse in any event, even if they are. Such conversation will be subject to legal privilege. Why is this relevant? This isn't relevant. This is like addressing a different problem. Conducting an arbitration is not reserved legal activity. This is where you'd be wrong. It's not reserved legal activity. However, the conduct of the solicitor before a tribunal is still controlled by the SRA's code of conduct, and they need to comply with the SRA's principles. It is irrelevant whether they are in the presence of a court or a tribunal. So C is actually a misdirection here. And D is the correct one. E says the solicitor has been instructed by the client to have such conversations. No, because the obligation of the obligations of the solicitor are to the court. They're not to the client, right? So the client cannot actually instruct you to break the law or to violate the code of conduct. You're not obligated to follow those instructions. So question 76 was in the area of ethics of solicitors and what guides their behavior. This is something that gets examined throughout FLK1 and FLK2 because it kind of pops up in a variety of places. Most normally we find questions about this when we do sets about FLK1, but still remember that ethics and professional obligations are something that permeates the whole examination, so you might find it in other places as well. Right, how are we doing so far? If you're happy bunnies and you're enjoying the show, give me some sort of emoji that you know, put down the sandwich or the coffee that you're having and click the emoji button so I know that you guys are having a good time. Or, you know, maybe even if you're having a bad time, because maybe I'm assuming too much here. Maybe I'm assuming that everybody enjoys doing MCQs, which is it's a bit of a loaded assumption, right? Maybe most people would rather do something else during their lunchtime than answer MCQs. Alrighty, now we are moving on to our next question, which is going to be question 77 from the SRA's SQE1 sample. 77. A private limited company is in insolvent liquidation. The liquidator has sold the company's property and is distributing the proceeds to those entitled. The value of the company's net property for the purposes of the Insolvency Act, what is called the net property, is £100,000. The liquidator has not yet made any distribution to the following creditors: the company's bank, which is owed £110,000 and which holds a valid floating charge created 6 years ago over all of the company's property. There are also numerous unsecured creditors who together are owed a total of £50,000. The company only has ordinary shares in issue. The company's 3 shareholders each paid $5,000 for their ordinary shares, $15,000 in total. How should the liquidator distribute the net property? Your options are: the liquidator should ring-fence. Let me say this again. The liquidator should ring-fence a prescribed part of the net property for distribution to the bank and distribute the balance to the unsecured creditors. Option B: the liquidator should distribute all of the net property to the bank because it is valued at under £800,000. C: the liquidator should ring-fence a prescribed part of the net property for distribution to the unsecured creditors and distribute the balance to the bank. D: the liquidator should distribute all of the net property to the bank because the floating charge holder is not an associate of the company. E: the liquidator should ring-fence a prescribed part of the net property for distribution to the shareholders and distribute the balance to the bank. Okay, now I don't know how you guys feel about it, but I think this is a horrible question. I know it's a horrible. I know why I think it's a horrible question. You tell me how you feel about it. The reason is that everybody has got in their minds the list of distribution in insolvency. So at the beginning, you get the fixed charge holders, then you also get the administrators or liquidators' expenses, then you get the floating charge holders, then you have actually before you had preferential creditors, then you got the floating charge holders, then you've got the unsecured creditors, and at the end, if there's anything left, you've got the shareholders themselves. Key part here: the floating in your list of distribution and insolvency, the floating comes before the unsecured. That's why everybody feels sorry for you if you're an unsecured creditor, right? So with this broad categorization in mind, you might think this is a no contest issue here. The one who's got a registered charge takes priority over the unsecured. Therefore, you would have thought that the floating charge that is owed by the bank would beat everybody else, and then the bank would just kind of hoover up all the money. But you'd be wrong. I know. And you know what? I was kind of, to be honest with you guys, I read this and I got this wrong at the beginning. And I was like, Ha! Hang on a second. Like the question cannot be that easy. Let's investigate this. And this is, in fact, something that I don't tell my undergraduate students because it goes too much into the weeds. But thank you, SRA, for sticking a question on it. Oof! Now, they changed the law, guys. So, the Insolvency Act 1986 has been updated. And the change is that if a charge has been created after the 15th of September 2003, the liquidator is to set aside a prescribed part for unsecured creditors. That's why the question's telling you that the bank registered the valid floating charge 6 years ago. You see, nothing in these questions is there by chance. Everything that is put in the question serves a purpose. So if you're reading through it, you might think, oh, they did the charge 6 years ago. Who cares? The only thing we're interested in that it's a validly registered card. That's where they get you. Yeah. The reason why the 6 year is crucial is to allow you to check whether the charge was created after 2003 or not. So clearly, now this being, what year is it, guys? Now it is 2026. If the charge was created in 2020, mid-pandemic, then it was created post 2003, so it's affected by the new rules. So what do the new rules actually say? They will set aside the prescribed part. The prescribed part is 50% of the first £10,000 in the company's asset base, and then 20% of the remainder, in which case, up to a limit of 800,000, but that's not relevant here because they don't have that much money. So the total is £23,000. So according to the Insolvency Act as it currently stands, the liquidators are going to set aside £23,000 for the unsecured creditors and then give the rest to the bank to honor its floating charge. Now, why was this change introduced? The answer is banks tended to screw everybody over, okay, by registering floating charge of the whole assets of the company and therefore wipe out the unsecured creditors. So it was felt that this is giving them too much protection and it is unfair to anybody who's in an unsecured position, hence the change. So it doesn't mean that the unsecured creditors are fully satisfied, but it means they're getting more than they would have gotten if the charge was a lot older, because in that case, the bank would have just hoovered up the lot of the remaining assets. So correct answer is C, because of the change in the recent change, because the updated version of the Insolvency Act. Now, why are the wrong ones wrong? A says the liquidator should ring fence for distribution to the bank. No, it works the other way around, right? So you ring fence to protect the unsecured creditors, not the secured ones. B mentions a threshold of 800,000. It's not a threshold, it's a cap, right? So you don't go above that, you don't have to hit that. D is wrong because it says the liquidator should distribute to the bank first, which is not the case, as we explained. And E is wrong because it says the liquidator should ring fence for distribution to the shareholders. Everybody would have guessed that that's wrong because the parties who stand to lose out in this situation are, of course, the shareholders. Why? Because that is the deal. Because when you buy shares in a company, you benefit for unlimited upside if things go well. There is no ceiling to how much money you could earn if things go well for the company, but you've got a bottom to the downside. So the worst thing that can happen to you is that the company goes insolvent and you lose the money you paid to purchase the shares. It does not go after the rest of your personal wealth, hence the kind of veil of incorporation and limited liability and all of that stuff. Yeah. So that's the deal for the shareholders. If the company goes bust, they don't get anything. And this is an insolvent liquidation, meaning that they went bust because they ran out of money. So there's unlikely to be anything left. Yeah. So all in all, good news. If you didn't know this, you know now. Good news for unsecured creditors. They're not in as bad a position as they used to be. Now, if you guys are enjoying the audio-visual resource as you do, because you're now here. Terrific. If you would like a top-up in textual resource, I have finally given up to public demand, and I have created textual resources, and I'm using Substack to distribute those. So I've put a whole bunch of free resources there. I've got infographics, I've got flashcards, I've got various explanations. Everybody can watch these for free. But I'm also creating some really nice guides to explain each part of the FLK. So these guides are available to subscribers at the moment. So in order to get them, you can either subscribe directly on Substack for $4.99 a month, or if you are subscribed to this channel already and you're on the preppers level, which is $5.99 a month, then you get a complimentary subscription to the Substack, so you can, participate in all of this stuff that's members only, and then also you send me your email address and I give you a free subscription to the Substack, and you can download all the resources from there within the one subscription. So if this is something that you guys are interested in, feel free to explore this. Otherwise, you can have a look at the free resources on Substack and see what it looks like. And there's also, you can do a trial. So that's the link, I'm putting it here in the chat. You can also do a trial and look at the paid for resources for a while to see whether you enjoy them or not, and take it from there. Okie dokie. So are we ready to gallop onwards to question 78? We are burning through these questions today, man. We're on fire. Yeah. Okay. Let me move our screen to the next one. Football related question. Everybody loves those. You guys are sports fans? I am not. I'm not even gonna pretend. I'm not. I'm as far away from a sports fan as one can actually get. Yes. But we have currently the Olympics going on. If you're watching this on the replay, yes, this was filmed in February 2026, while the Milan Olympics were taking place. But our question is not about skiing. Our question is about football. A footballer aged 17 enters into a long-term contract with an agent to negotiate commercial contracts on his behalf as a professional football player. The footballer's parents are not co-signatories to the contract. A month later, when the footballer is still 17, the footballer decides that he no longer wants the agent to represent him and that he wants to bring the contract to an end. Question for you guys. Can the footballer terminate the contract? Now, strangely enough, I've got a short video on capacity and minors as part of my series for the FLK law of contract. And that video has been doing fantastically, even though it's like from years ago. And I was wondering why. And I realized that minority is not actually an issue that is much discussed. So if you're going around Googling for the rights of minors and what the various things mean, you don't really have a lot of choice in the resources. So a lot of people end up watching my short video on the rights of minors. So your options. Can the footballer terminate the contract? A says no, because he is of full capacity, being over 16 years of age. B says no, because it is a commercial contract and not a consumer contract. C says no, because he's a minor and it is a contract for necessaries. D, yes, because he is a minor and it is not a contract for necessaries. E says yes, because his parents were not co-signatories to the contract. All right. Were you to choose an option, which one would you pick? Or if you don't want to venture a guess, is there an emoji football in here? Go on, find the person who finds the football emoji gets a round of applause. Yeah. Let's see which one would be the correct answer. The correct answer, ladies and gentlemen, is D. Can the footballer terminate the contract? Yes, he can, because he is a minor and it is not a contract for necessaries. Alrighty. What are necessaries? Necessaries are the stuff that you have to obtain in order to keep you alive. So basics such as shelter, clothing, and food. Yeah. And associated things that have to do with kind of securing habitable spaces and so on. So if the minors cannot enter into contracts unless we've got specific circumstances, and if they do enter into contracts, these contracts are in some cases void because you're not allowed to have them with a minor. Sometimes they're voidable if the minor wants to get out of them. The only ones that are sticky, meaning they've been performed by a minor, but the minor cannot get out of them, are the contracts for necessaries in the reason that for the reasons that I explained. So if a minor goes and gets a can of baked beans from Tesco's for lunch, then this is a contract that they cannot get out of. But if they get an agent to represent them, then this will not be necessary. Therefore, it is voidable. What is the age of majority? I heard you say. What is it? Quick answer in the chat. What is the age of majority in the UK? Come on, you know this. It is 18 years of age. Do not confuse the age for criminal liability with the age for contractual liability. Due to a variety of changes in criminal law, people that are underage, they could be liable for kind of full the treatment as full adults, depending on what's going on. Yeah, but that's criminal law. Here we're talking about contract. So our reference here is the Family Law Reform Act of 1969, which determines the age of majority at 18. So any contract that is concluded by somebody that is below 18 needs to be assessed as a contract for minors. And as I said, even if it's a contract they're entitled to be to conclude, the contract will be voidable unless it is there for necessaries. There we go. Not a bit of a niche area, not something that we're gonna see all the time, but it is there. Let's move on to our next question, question 79. By the way, if you guys are not yet subscribed to my newsletter, you should. So send an email to newsletter. Did I spell this properly? Newsletter@glintis.co.uk. And I will enroll you onto my newsletter. And every Monday, you're going to get an email containing a fresh MCQ, a full explanation and reading material about the previous week's MCQ, and a whole stack of useful links that you can do additional things with, links to resources that I provide that you can find hosted on my website, or things that you can buy or services that you can get from other suppliers with discount codes and stuff like that. Because the idea is, I know that you guys are paying an absolute fortune through your prep, so I'm trying to do whatever I can to help, either by offering you really cheap options or free options for prep online, or by giving you discount codes for the stuff that you have to buy and you cannot avoid. I mean, our most popular discount code is the one for Revise SQE that gives you 10% off. And we're getting a lot of conversion on that one because obviously these are the best books available for the SQE at the moment. So, why not have them at a discount? So if you guys are interested in that, drop me an email at newsletter@glintis.co.uk and I will add you to my fantastic subscribers list, mailing list. Yes. Now, question 79. The law on land taxation tax in Wales is under review, with proposals being made to increase the tax to be paid for properties that are used as holiday homes. A woman registered to vote and living in Wales, but who is English, wishes to express her opposition to the proposed changes. Okay, She intends to write to her elected representative who sits on the body which has power to vote on this matter. She would like to know whether she should write to her member of parliament at Westminster or to her member of the Welsh parliament. Which elected representatives should the woman write to? Your options are to her MP, because it concerns a reserved matter for the UK Parliament, to her MS, because it concerns a devolved power of the Welsh Parliament, C, to her MP, because it concerns a conferred power of the UK Parliament, D, to both her MP and her MS, because it concerns a joint power between the two parliaments, or is it E, to her MS, because it concerns a reserved power for the Welsh Parliament? Aha. Right, now the confusion here is probably going to come by figuring out the terms devolved and reserved power and conferred power and so on. Now, due to the constitutional devolution arrangements that we've got, primarily the Scotland Act of 1998 and the Government of Wales Act of 2006 as amended in 2017, everything is devolved except matters that are reserved, for example, immigration, defense, that kind of stuff. And if we're looking for devolved power, we're looking for everything that flows down, right? If we're looking for reserved power, we're looking for these particular areas that are exempt. If we're looking for conferred power, we shouldn't be looking at it at all, because this was terminology that was relevant to the prior situation under the Government of Wales Act 2006 before it was amended in 2017. So the word conferred is out of date. So in trying to find the correct answer, we eliminate the ones that say conferred, so we lose C, and then we have to choose between the rest of them. The correct answer is that she should approach her MS, the member of the Welsh Parliament, because this is a devolved power. It is not a reserved matter, right? This is a specific area of exemptions to the devolution. Charges, taxes, and stuff on property is not one of these reserved powers. So A is wrong because it talks about reserved. C is wrong because you use the terminology conferred, which is gone. D is wrong because it says ask both, and that's not the case. And E is wrong because the concept reserved power is reserved to the UK government, right? Not reserved the other way around. So the correct answer is B, to her MS, because the taxation of property is a devolved power that belongs with the Welsh Parliament. Now, this is in the constitutional law, like public constitutional law, administrative law, part of the FLK. I don't know whether you guys are spending a great deal of time revising those ones. I'm getting the feeling that the constitutional law arrangements are getting a little bit overlooked, and also they don't tend to generate that many questions from what we're seeing, from what candidates are reporting after having experienced SQE1. Constitutional law is not something that comes up very frequently as a topic. So either people know this and they don't get it wrong, so they don't agonize over it, or it just doesn't come up as often. But since you're getting examined on everything and you cannot take the risk of leaving anything out, if you're very unfamiliar with the British Constitution and constitutional arrangements, it might be a good idea to have a little bit of a look, just to be sure that you're on top of everything that you need to know. Yeah. Alrighty. Now, let's move on to our next question. This is question 80. A man is arrested and detained at the police station on suspicion of common assault. This is a summary-only offense. The man is homeless and has no income. The man is not legally represented during his interview under caution, in which he denies the offense. After the interview, the man is told that he will be charged with the offense. The man states that he now wants legal advice, and he does not want the police to charge him. Is the man entitled to publicly funded legal advice at the police station? All right. Your options are no, because the offense for which he has been arrested is a summary-only offense. Yes, because he has no address in England and Wales. Yes, because he has been arrested and is in custody at the police station. Yes, because he satisfies the means test. And no, because the interview under caution has already taken place. Now, this is a criminal procedure question. The statutory reference here is going to be the Police and Criminal Evidence Act of 1984. And clearly, we're talking about the provision of free legal advice, which is legal aid. This comes under the Legal Aid, Sentencing and Punishment Act of 2012. Now, what you basically need to know about this is that this is not means tested. So it doesn't matter if the man has wealth or not. And everyone is entitled to free legal advice if they've been arrested and they are in custody. So the correct answer is going to be C. Yeah? Now, the other options are wrong. A is wrong because this isn't, whether it's a summary offense or a more serious offense, doesn't matter. Whether you got an address in England or not, again, doesn't matter. I already said it's not means tested, which takes out D. And whether the interview has already taken place or not, or whether it was under caution or not, doesn't really matter. What matters is that you've got a person who's arrested and is in custody at the police station. This triggers an entitlement to free legal advice. Now, clearly, there's a bit of a problem with representation and free legal advice, and legal aid is a very, very pressured and underfunded and kind of ridiculously malfunctioning system, but that's a debate for another day. The correct answer here is C, because anybody who's arrested and in custody has the right to legal advice. Yeah. Hopefully, we will not get to experience this for ourselves. But even if you don't intend to go into criminal litigation or to kind of try and assist people upon arrest at the police station, you still need to know about this for the purposes of the SQE. All right. Now, we're going to move on to our question 81. For the last 24 years, a man has run a business from premises on the outskirts of a village. The man obtained planning permission for this business use when he started his business. The only house in the immediate vicinity of the man's business has been owned and occupied by a woman for the last 22 years. The noise from the man's business has always been considerable, but the woman did not complain because her father was friends with the man. The woman's father died 3 months ago, and she has now brought an action in private nuisance against the man. It is accepted that the noise levels, which have not changed since the business started, constitute an actionable nuisance unless the man can raise a successful defense. So, question for you guys. Can the man successfully use the defense of prescription? Okay. Possible answers are no, because the claim only became actionable when the woman complained about the noise. Yes, because the man has run his business for more than 20 years without complaint. No, because the defense does not apply to private nuisance. Yes, because the man has obtained planning permission. No, because the woman came to the nuisance after the man had begun running his business. Okay, now let's take a second to sip our coffee and think about it. Do you guys know what is the defense of prescription? It is a type of easement. So a defendant in a nuisance case can acquire an easement by prescription if the nuisance has been continuous and actionable for 20 years and nobody did anything about this. So the relevant time is from when the action became actionable, and it becomes actionable when the nuisance begins, not when somebody complains about it. So A is wrong because it takes the wrong yardstick in determining when the nuisance becomes actionable. C is wrong because, yeah, this defense does apply to private nuisance. This is the key defense to private nuisance. D is wrong because whether the man had planning permission is irrelevant as to whether his activities are actually constituting a nuisance. I mean, having planning permission for a factory doesn't mean that you can keep everybody awake for the next 20 years. E is wrong because whether the woman came to the nuisance after the man has started running the business is irrelevant. So if it's a nuisance, it's a nuisance. It doesn't mean that, you moved next door to him, therefore it's your fault. So the correct answer is B, that says, can the man successfully use the defense of prescription? Yes, because the man has run his business for more than 20 years without complaint. Yeah. So this is one of the key defenses, as I said, to an action for nuisance. If you've been sitting next to something that would constitute an actual nuisance, but you haven't done anything for 20 years running, then you accept this, and it would be considered unfair on the other party to go and complain about it and disrupt their business. Okie dokie. Let's try question 82. So we're rapidly tumbling towards the end of the first set of questions from the original set of the SRA's sample questions, which was a set of 85 questions that they released or updated in an event in April last year. So 82. A solicitor is acting on behalf of a claimant in her claim against a local firm of accountants. The claimant's claim is that she acted on negligent advice provided by the defendant. All appropriate pre-action procedures have been followed and proceedings have been issued and served. The solicitor receives an email from the firm of solicitors acting for the defendant, which explains that the solicitor who had conduct of the matter has been absent from the office due to ill health. The firm has filed the acknowledgement of service with the court on behalf of the defendant, but requires an extension of time in order to prepare and file their client's defense. The claimant solicitor agrees to an extension of 7 days for the filing of the defense, and the court is notified in writing. On the date that the agreed 7-day extension period is due to expire, the defendant solicitor requests a further extension to the time for filing the defense. What is the maximum further extension, if any, to which the claimant solicitor can agree without the permission of the court? Is it 7 days? Is it an extra 14, an extra 21, an extra 22? Or is this a situation where no further extension is permitted? Oh, Thanos has joined us. Thank you for contributing there. So Thanos is suggesting a further 21 days. Yes, I will agree with you. Now, unfortunately, this isn't one that you can guess, right? You will only know this one if you know the Civil Procedure Rule 15, Section 5. It says that the parties may agree to extend the deadline for filing a defense without the court's permission for a maximum of 28 days from the original deadline. So they already had here 7 days, and now they're asking for more. The maximum that we can get them to is 28 days. Therefore, if they had 7, we can add another 21. So the correct answer is C, a further 21-day extension. No, I don't particularly like civil procedure rules based questions because there isn't a way to kind of get your head around it unless you actually know what the rule is. So if you're not familiar with the rule, it's a guessing game. If you're familiar with the rule, you get the answer straight away, and there's no point in kind of getting into lengthy explanations as to why the wrong ones are wrong. But yeah, these do come up, and they do come up very frequently. So I would advise you guys to be super careful with the dispute resolution part of the FLK that contains the basics of the civil procedure rules and civil litigation. Okie dokie. So let's bundle on to question 83. You just bring this a little bit down. There we go. You guys can see the number. So question 83. A private limited company has unamended model articles as set out in Schedule 1 to the company's model articles regulations of 2008. The company has issued ordinary shares only and has no shareholders agreement. Its most recent set of accounts show that the company did not make a profit or a loss in the most recent accounting period, although it has have distributable profits of £50,000 carried forward from previous accounting periods. The shareholders want the company to declare a dividend out of these profits, but the directors intend to retain the profits within the company to finance an expansion of the company's trade. Question: can the shareholders compel the directors to recommend a dividend? Your options are yes, because the directors have a duty to act in the best interests of the shareholders. Yes, because the shareholders have the power to require payment of a dividend by ordinary resolution. Yes, because the shareholders have a right to receive a dividend if the company has distributable profits. No, because only the directors have the power to recommend the payment of a dividend. Or E, no, because the directors can only recommend a dividend out of profits for the most recent accounting period. Aha! This one I knew. This one's easy for me because I've been teaching company law for donkey's years. And this is obviously FLK business law, an area that most candidates are finding easier to navigate because it's kind of they're more likely to be engaged in this in the line of everyday work. Nonetheless, it is an area that you need to obviously revise and study to make sure that you're not missing anything out. Right, so do we have any suggestion here as to what should be the correct one? Okay, we've got a suggestion in the chat saying E. I am afraid I'm going to disappoint you on this one. It is not E. It is the harshest option. It is D. No, it is only the directors that have the power to recommend the payment of dividends. If the company has got excess money, then the directors could choose to distribute them as dividends. This isn't limited to the accounting period. So we're not looking at sort of this of the previous years or this year's turnover in order to allow or profit to allow us to make decisions on the distribution of dividends. It can be carried over or existing cash that has remained in the accounts for historical accounting periods. But be careful here. It is only the directors that can make the recommendation. Then the shareholders cannot choose to accept it or not, but the shareholders cannot make the recommendation to pay themselves dividends. Let's go through the other ones. A is very wrong. The directors have a duty to act in the best interests of the company, not the interests of the shareholders. Yeah? The best interests of the company means existing and future shareholders. If you said that they're obligated to act in the best interests of the current shareholders, then they would have an incentive to just dish everything out in order to satisfy the existing shareholding as it is at the moment, right? But this is not. According to the Companies Act, their obligation is to the company, present and future, containing the potential of the company to do stuff in the future. So A is wrong as a point of law. B is also wrong as a point of law. The shareholders do not have the power to require payments of dividends. Now, the shareholders have the right to receive a dividend. They don't have the right to receive a dividend. They have the potential to receive a dividend. Again, C is wrong. So all of them here are very wrong on the law, apart from D, which states the correct position. It is up to the directors. It is one of their powers to recommend the payment of dividends. So my apologies to you if you're a shareholder that hasn't received dividends in a while and you were getting a bit antsy and you thought that you can force the hands of the company. Unfortunately, you cannot. Okay, now, this is our penultimate question. Question 84. A sole trader who operates as a builder's merchant enters into a contract with the company to hire a forklift truck. The terms of the contract are in writing, and the sole trader is given the opportunity to read the contract in full before he signs it. The sole trader, as everybody else, does not read the contract but does sign it. The signature clause says in bold capital letters, "I have read the contract in full and understand its terms." The contract states that the hire of the forklift is for a fixed 3-year term and that there's a fee payable to the company if the sole trader wishes to terminate it early. The sole trader tries to return the forklift 6 months after signing the contract because he has found a cheaper alternative. The company requires the trader to pay the stipulated fee for early termination. The trader is not happy. He then reads the contract. He claims that the clause was not incorporated into the contract because he had not read it and he had not dealt with the company before. Question for you. Was the clause incorporated into the contract? I've been teaching contract law for so long. If you get this wrong, I'm going to be seriously offended. Things that we can insist, we bang on about this to first-year undergraduate students when we do contracts. How do clauses get incorporated into contracts? Can I have your suggestion? I will be very angry. Right? At the same time, if I say this, I scare you off, and then you don't want to offer a suggestion. But the methods of incorporating a clause in a contract are by signature or by notice. Yeah? If you've signed it, it is game over. And we've got plentiful case law to support this. Usually we cite the case of Lestrans versus Greycop, but that doesn't matter for the purposes of the SQE. Signed, dead. Okay? If you sign it, it's over. So yes, Thanos is correct. The A is the correct answer. Any requirements as to where the notification should have been put and whether people were given the opportunity to read it and, the circumstances of what happened, all of that is only relevant if we're talking about incorporation by notice. Like the format, the time, all of that is only relevant for incorporation by notice. From the moment that somebody has signed it, it is game over. We don't care about the rest. So the correct answer here is A. B, that says no because the clause was not specifically drawn to the sole trader's attention. That would only be relevant for incorporation by notice, and it would only be relevant for severe clauses with consequences like penalties, which is the case here in a way, or compensation, or exclusion clauses or something like this. It is not relevant because it's signed. C says no because there was no previous course of dealing. We don't care because it's signed. D says yes because the sole trader was acting in his capacity as a business or a consumer. That part is irrelevant. Yeah. E not because the sole trader did not read the clause, blah, blah, blah. We don't care. He signed it. So don't sign stuff without reading them. Okay? And if you do, you take your chances. Now, of course, nobody ever reads. Whoever reads the end user license agreement when they're trying to get some software, or who reads, the terms and conditions when they're shoved in front of your face for a rental for a car. We don't, but we should. The important thing to remember is, from the moment we signed it, we're telling the other party that we have knowledge of the terms, even though in reality we don't. I mean, the law needs to operate with some assumptions, and this is how these assumptions are made. Guess what, guys? We made it to question 85. Well done, everybody. Okay, so this is the end of the first big set of the SRA's FLK1 sample. And that gives me the opportunity to do two things. One is to put together like the big video where I talk for this batch of questions from like 70, what was it? Like from 70 till 85. And also it allows me for the next stream, the next member stream that we're going to have, I'm going to talk about FLK2, because we haven't spent as much time on FLK2 as we have on FLK1. So it's the time to get back on the horse on that one. But before we go there, let us finish with question 85. A local authority has statutory power to to purchase in a compulsory way land for the purpose of building residential houses and access roads to those houses. The local authority approves a development plan and intends to acquire the land needed for the development by way of compulsory purchase. The development plan includes a new housing estate, a large cinema and shopping complex with a dual carriageway passing through the new housing estate to provide necessary access. How does the dual carriageway provide access? I haven't quite understood, but we'll leave this to Kaplan. A local resident whose land would be compulsorily purchased under the development plan wishes to bring judicial review proceedings against the local authority to challenge this development plan. Which of the following best explains whether the local resident can bring judicial review proceedings? Is it A, he can do so because the facts suggest the local authority may have acted illegally? B, he cannot do so because planning decisions are not subject to judicial review? C, he can do so because the facts suggest the local authority's actions may be procedurally unfair? D, he cannot do so because proceedings cannot be brought by a single resident? Or E, he cannot do so because the local authority is acting within its statutory powers? Okay. What would you guys suggest? Let me just... Would you say it is A, B, C, or D? Are you guys familiar with the GCHQ case? Yeah. That is the kind of main reference case for judicial review proceedings. Obviously, we're dealing with the part of the FLK that has to do with administrative law. It's like constitutional and administrative law, and the opportunities for challenging government action through the courts, through the administrative courts. So let's read the question carefully from the beginning. A local authority has statutory power to compulsorily purchase land for the purpose of building residential houses and access roads to those houses. These are the boundaries of the statutory authority. What they've done is that they want to expropriate people's homes in order to build that stuff, but in addition, they're building a cinema and a shopping center. This goes beyond the statutory authority. So if you look at cases like the GCHQ case, one of the key grounds for illegality is going ultra vires. It means that they're going beyond the legally provided power. Yes. So Thanos has put this in the chat. Thank you. Going beyond the given power means that they are engaging in an approval procedure that is in fact illegal. So the correct answer here is going to be A. Why are the wrong ones wrong? B says he cannot do so because planning decisions are not subject to judicial review. That's wrong. Okay, of course, planning decisions are subject to judicial review. If anything, the main thing that goes through the admin courts is complaints about planning permission. C says he can do so because the facts suggest the local authority may have been the actions may have been procedurally unfair. We don't know anything about this. This is not supported by the factual basis in the question. They clearly misunderstood what they're allowed to do, right? But there's nothing to suggest that the process for doing so was wrong. It's not like there's any indication they got bribed by the developer or something, right? Or, or somebody's cousin was involved in the business. So there's nothing about procedural impropriety. The problem is straight exceeding the authority. D says he cannot do so because proceedings cannot be brought by a single resident. That's wrong on the law. A single resident that is affected by the decision has standing in the administrative courts to bring judicial review proceedings. E says he cannot do so because the local authority is acting within its statutory powers. Well, I mean, we don't know this. So we don't know whether they are or not. That's why we need to have this discussion. Now, admittedly, there's a commonality between A and E, right? Which brings me back to my previous point that you're looking for the best possible answer. You're not looking for a perfect answer and all the rest of them to be garbage, right? So you might be confused with E because if they're going beyond their legal powers, then actually he says he cannot do so. Yeah. I think this is why this is wrong. Because if it said he needs to test whether it's within the statutory powers, it would be very close to A. But since E says he cannot because they're acting within the statutory powers, this is what makes it wrong, because the whole assumption here is that they went beyond the statutory powers. So we have successfully eliminated B, C, D are clearly wrong. E is also wrong. It needs a bit of thinking. A is the appropriate answer. This looks like an ultra vires act, which would make this a very good prospect for judicial review.